With due respect, my lord, I beg to mention item number 14 and 15, my lord. In item number 14, I am appearing for the respondent, my lord. In item number 15, learned DSGI is appearing, my lord. So, petitioner's counsel Tidas is coming from Delhi. Today, my lord, DSGI is not appearing, is out of station. And because of that, he also informed the petitioner's counsel he is not coming from Delhi. And both the matters, my lord, maybe
Item 14, 15 at the request of Mr. Porakhor be adjourned for 3 weeks.
And for the petitioner, Lordship, kindly a date may be fixed, 10th of October, Lordship.
because he is coming from Delhi, my lord.
End of October.
10th of October,
10th
he is
of
saying.
October,
10th of October, we don't know. It's too far away.
Lordship.
10th of October, we don't know whether
Lordship,
we
because
continue
it's a
because it is
outreach,
just before the closure.
Yes, Lordship.
So it not be possible for may not be possible for a hearing. We can have it in November if you want.
Lordship, 10th of October after that, 10th of October, Lordship.
Then
I-
10th of October, this matter is for what?
Lordship, for hearing.
It can't be heard on 10th of October.
Last week.
It's the last week before the closure. So may not be possible, I'm saying.
November.
You can have it. You can have it in the early part of October or in the beginning of November. 2nd of November.
Lordship, let it be on 10th, then after that we'll fix the date, Lordship.
He is booked.
Because it's
We are adjourning it for 3 weeks. You make a mention after that.
okay, Lordship, for
Yes, 3 weeks, 4 weeks.
4.
At the request of learned counsels for the parties, matter stands adjourned for 4 weeks.
Obliged.
Lordship, with the consent of the addressor, my lord, I beg to mention item number 7, my lord. As per my lord direction, I have received the original record, my lord. My lordship, due to some medical emergency, I have to leave the court early, my lord.
Have you informed the petitioners?
My lord, yesterday, my lord, I have informed the petitioner.
Item 7,
I have received the original record, my lord.
when can you see? The problem is when we fix a matter, it is difficult to again refix a matter on some other date.
But lordship, I am suffering from severe.
It's all right, all right.
I have to remove my teeth today, my
No,
lord.
that's okay. We are not asking you for your details of your
Lordship,
medical treatments.
I have received the original records also, my lord.
This is a 2015 matter, so
My lord. Next week is lordship, as per my lord convenience.
Utami. So we are saying let it come in the week beginning from. We are passing it over for the week.
My lord,
We are passing it over for the week.
if they have, they may also mention if they have urgent petition.
No, it will come.
Lord.
You get ready with your medical treatment.
Yes.
All right.
My lord. I'm deeply obliged, my lord.
Yes.
Yeah, please. Lordship, in reference to the 2015 notification, we do not have any policy because the matter was at that time put under the cap in abeyance. Until that, it's keep going on. And the policy which we have it at present in the Indian Bank, because your Lordship might remember that earlier it was Allahabad Bank when the notifications or advertisement was issued. And on 1st of April 2020, the bank got merged into the Indian Bank. So thereafter, this policy we are having. So in reference to the 2015 notification, we do not.
What does it say?
Your Lordship, at page number 12, there is an only that for the sub-staff cadres
What is staff cadre?
that there is no particular scheme for the sweepers.
No, what is sub-staff cadre?
Is for
Page number
housekeeper.
12, page number 12 you're referring to?
Yes, your Lordship. That is 4.4.2.
Hmm.
That is that the housekeeper come peon.
Where are the cadres defined?
That is A, that is housekeeper and some peon, your lordship, at page number 12 itself.
Housekeeper come peon.
Yes.
How many housekeepers you have?
That is in present data, but we do not have any.
No, no. What we want to know from you, that you are extracting service from a group of persons
Yes, your lord.
on the ground that we cannot appoint you because of this advisory. We are not decided on how to proceed on the selection process, but you keep on working. That's a very comfortable way of for the management.
Yes.
But you are extracting work from people without expressing your reasons or your necessities, whether you require them on a long-term basis or not.
No, we hired them on the daily basis.
That
if-
you can't do.
Suppose if we.
No, you can't do that.
Yes, sir.
Where is your policy for hiring on daily basis?
No.
Then you are doing something beyond our policy. Beyond your policy. Where are your cadre strength? Where is the cadre structure described? This is only for, is it also for officers?
It is also for the office. It is for all, your lord. Right? It is a common policy that has been. It starts from page 1 that the policy supersedes and replaces the recruitment policy dated 2/8/2016, and the policy is the property of Indian Bank. Thereafter,
Yes, Mr. Chakraborty.
My lord, lordship will first see that this policy has come on 2/8/2016. And the
No,
interview-
see, let us be clear on one thing. There is a advisory by the government based on whatever policies they have framed to say that the process of selection by way of interview has to be abandoned.
discontinue
Discontinue.
means stop.
Stop. Now,
For
there is no clear advisory as to what happens to those interviews which have already taken place. This is one. The second is the banks were advised to adopt other measures for selection. So it was open to the bank to stop this process of interview and then re-advertise or go for a fresh selection. They've done nothing. Now, your claim to say that these advisories will be with effect after 31st of December.
My lord, why I am saying that it will be applicable after 31st 12.
No, you are right. It is
If-
see, it is applicable. There's no doubt on that. But the question is, this is an advisory which is issued on the basis of some policy adopted by the government.
My lord.
The policy doesn't say that with effect from 31st, we are changing our recruitment policy. That's not the advisory. Advisory is very clear. Stop all process for interview.
No, that is perhaps not.
Where is the advisory again?
This is page 42. Annexure 7, running page 42, earlier it was page 7. My lord, in its meeting held on 13/11/2015, has recommended discontinuation of interview in the recruitment process in public sector banks for junior level post by the deadline of 31/12/2015.
Discontinuation.
My lord, what I have understood, my lord, discontinuation means stop. And what can be stop?
Discontinuation may also mean abandoning the process.
Yes, it is saying the abandoning the process of selecting candidates by interview. it has not abandoned the recruitment process as a whole.
Exactly,
So,
absolutely.
my lord, what can be abandoned or stopped? Thing which is yet to come. To stop something, one thing which is yet to come, and what has
We
already
are
happened.
with you that the selection process could not have been abandoned.
Yes,
The manner of selecting, you may change it, you may not change it. That's a call you have to take. If the bank has
you have
taken
to
a,
change it by 31/12/2016, 15. You have to change.
I will read it that you discontinue the interviews latest by 35, the latest by 31st.
Yes.
Means even before 31st, you start discontinuing the process of interview and change it.
That is
But
what, my lord,
31/12
can
is the outer
policy-
limit.
My lord, can a policy decision will have a retrospective meaning when the decision is not clear?
It might,
Otherwise, they.
it might, it
No, my
might.
lord.
If the
That is-
policy,
In that case, my lord may
no,
have
no,
a
no,
look.
policy decision, Mr. Then you have to go through the promissory estoppel and all
No,
these
not
issues.
promissory estoppel, because lordship will have a look at the 1990 Supreme Court 3 SCC decision.
You have a look at the later Supreme Court judgments, Hero Motocorp. It's in a revenue matter. Have a look how the policy decisions have been changed.
Lordship may come to that for a moment, have a look at that judgment.
I agree with you entirely. You are
Now,
correct. You are
is-
correct that a policy having been taken ought to have been implemented. We are not on that. We are on this process that the policy is only for stoppage of interview,
Stoppage of interview.
not for cancellation of the process.
Stoppage of interview means, can an interview which is over can be stopped?
Maybe, but the question is the whole process of selection. Policy is stoppage of selection through interview. So assuming your interview is stopped, you'll still be, if the interview is accepted, you'll still be uh, uh, considered to be selected or
Now,
rejected on the basis of the
If we
interview.
read further, this
Now,
instruction, it says
the
that
flip
banks
side,
are-
the flip side is, why are you presuming that you are selected for the interview?
No, my lord. It is not our case. We are not presuming. We just want the results to be declared. Because the advisory further states that the bank should take a call and amend the policy.
Exactly,
So
exactly.
now, my lord, if your lordship comes to the last annexure, what the Allahabad board did, page number
So,
45.
so what we propose to do, what we were thinking of doing, is to close this petition with a specific direction that within a time frame, they will publish their policy or discuss or reflect their policy for the process of selection to these, if they are called sub-staffs.
My lord, may
But-
for a moment
but-
come to page 45. my lord.
But the benefit of your service and the age relaxation will be provided.
My lord, may for a moment come to page 45. That is
40,
the
40,
45.
45.
Now, in terms of that advisory, what they have done, proposal for, that is a board meeting, proposal for amendment of recruitment policy, discontinuation of interviews and recruitment process for clerical and subordinate staff as detailed in the agenda. It was resolved that approval is accorded for amending the selection criteria by discontinuing the interview process for recruitment in clerical cadre and subordinate staff, excluding sweeper. Now, and the proficiency test, so and so, and also resolve that till receipt of clarification, permission from Department of Financial Service, the process of recruitment of sweepers may be kept in it. So, my lord, they have understood the circular in a way that it has to be amended so far clerical and sub-staff are concerned, and they have approved it. That is, it is a prospective approval. So this amendment of the service rule condition will be operative from the day this resolution was taken. And so for the sweepers are concerned, they have just kept in abeyance without issuing any amendment to the recruitment policy.
That is what we propose to direct.
Now,
them.
my lord, if your lordship looks up that 1990 Supreme Court decision, lordship may just have a look at page number 166, paragraph 13.
What is the judgment? Gosavi?
1990,
Judgment will be- We'll just take out a copy.
is there in the record, my lord. On the last day, I had given that copy, my lord.
They seem to disappear. We don't know why. It's not here.
1993 SCC 157.
All right, you read. What does it say?
My lord. 157. Now, in paragraph 13, what the Supreme Court says?
1993 SCG,
Yes. Paragraph 157.
157 para.
It is, no,
Paragraph?
Page number.
Yes,
I
paragraph.
will be relying on paragraph 11 and 13.
Yes.
It is well accepted principle of construction that a statutory rule or government order is prospective in nature unless it is expressly or by necessary implication made to have retrospective effect. Where proceedings are initiated for selection by issuing advertisement, the selection should normally be regulated by the then existing rules and government orders. And any amendment of the rules or the government order pending the selection should not affect the validity of the selection made by the selecting authority or the Public Service Commission unless the amended rules or the amended government orders issued in exercise of a statutory power either by express provision or by necessary intendant indicate that amended rules shall be applicable to the pending election. So, my lord, if we go by this judgment, what I have understood that they have taken a decision to discontinue the process of selecting candidates by interview.
Exactly.
And that discontinuation should be made effective latest by 31/12/2015. Now, this circular does not indicate anything as to whether this circular will have any effect on the pending recruitment process, as has been held by the Supreme
Correct.
Court. Now, if that circular is not indicating any impact or effect on the pending recruitment process, then this circular is prospective in nature. Now, the amendment has
It is prospective in nature. If you take it that it has some meaning to the selection process. It indicates something for the selection process.
yes,
Then it is prospective. But the circular is very categorical to say discontinue latest by 31st.
yes.
It
So-
doesn't say discontinue after 31st.
Latest by 31st means you can, that is after 35/12/2015, you cannot have a process of selection by interview.
No. It means, subject to correction, as far as I understand, the process of selection adopted by interview has to be abandoned
Yes,
and latest by 31st.
yes. That
So
means
therefore, you
by
may not,
31st,
it may not strictly indicate that the selection itself has been abandoned, but this
latest by
process of selection through interview.
Now, my lord, the board have understood this circular and taken a decision that so far the recruitment of clerk and sub-staff is concerned, they will frame a policy. And so far the whippers are concerned, my lord, they have kept in abeyance for a clarification. Now that clarification is nowhere to be seen. What is that clarification? Whether at all any clarification was issued by the union government. Now, my lord, what I am submitting before your lordship is this Indian bank policy is of substance and that has come on existence on with effect on 2/8/2016.
Just 1 minute.
So, my lord, this 2016 so far substubs are concerned, my lord, lordship may come to page 12. There is nothing to show how the selections will be done. And whether
Once the interview is conducted, no further change is possible. That proposition
no, my lord.
will have
What
difficulty
is
accepting.
waiting for a lordship is,
That once the interview is conducted, there is a vested right in your favor.
that is one aspect. Other aspect is, once an interview or a selection process is initiated, where the process of selection is by way of interview, that has commenced, and during pendency, some changes have come, then those changes will not affect the pending interview.
That's what I'm saying. That is what I'm saying, that there's a vested right once you have set for the interview.
Lordship takes up the judgment once again, and just.
We are trying to get one judgment for you
My lord.
with regard to the change in policy. But the host that, what I notice is that the process for selection has not been abandoned. It has been kept in abeyance.
Yeah.
And it has been kept in abeyance from
2016.
2016.
Now, either they will have to place on record the clarification whether this will have a retrospective effect. That clarification has to come from the union government, or they'll have to proceed because their amendment is not so far the sub-stuff is concerned.
Yes, yes. Not sweeper. Okay.
Sweeper is concerned. Sweeper, the board decision is very clear. They have resolved in 2016 that they will have a fresh policy so far as clerks and sub-stuffs are concerned, excluding sweeper.
What is the amount you are being paid?
Nominal, my lord. That
Is it,
It is not in the scale of pay. It is just a daily.
it is not a minimum scale of pay?
No, no. That is why the recruitment, my lord, half or two-thirds scale of pay. There are two categories. If your lordship takes up that
Yes, yes.
advertisement.
Yes, we have seen it. Half or two-thirds.
two-thirds scale. Now, my lord, the bank is basis nothing but exploitation, my lord.
Exactly, exactly.
So if it is a case of exploitation, and this, we are not before your lordship for a declaration, anything beyond the result. We do not know. In spite of our best effort, it may come out that none of the petitioners got selected.
No, because the results being declared, perhaps you still may not have a right, assuming you are selected, to say that, no, now you should be given an appointment. Contrary to the advisory which is being given, because
Then in that case, lordship will have to hold that this advisory will have a retrospective effect. If
this advisory is an advisory to the bank to say that the manner in which you are conducting the selection, you abandon it. Change your policy, go for fresh. There's nothing wrong in the advisory. Problem has been created by the bank by maintaining a status quo.
now in that case, lordship will have to interpret the advisory. What is the intention of the government? Whether the government wanted to solve the pending cases, or it wanted to make it clear that whatever is done, but by 31st/12, you cannot carry hold
The
any.
first proposition does not appear to be the interpretation on a plain reading.
that
On a
is-
plain reading. But yes, having embarked on this process of interview, they have comfortably stalled it,
Yes,
and now they're extracting service on a daily
and
wage
they have
basis.
not even amended.
Then
the-
you'll have to give them their minimum of pay scale. You'll have to give them. You have to give that amount. First, you tell us what is the status of your policy decision. What policies have you brought out against pursuant to this page 45?
Your lordship, it is still kept in abeyance. We have not done anything more than the situation.
Then then we'll direct them to release the minimum of pay retrospectively. What is the amount? You tell us. What is the scale of pay?
Whatever the scale, it is there in the bank. I do not know the scale. So if your
You
lordship-
give us the scale of pay.
Your lordship kindly pass.
Why
lord-
can't you be posted with a complete instructions? You are appearing on every date and asking for time for instructions.
No, your lordship, regarding this pay,
My lord, may direct the bank to get a clarification from the union government, Ministry of Finance, a matter of.
That they have,
No,
perhaps.
They don't.
They have
have.
applied. You
No,
applied? No.
no.
because if your lordship goes to that board resolution of Allahabad Bank,
45.
45, also resolved that till receipt of clarification permission from DFS, the process of recruitment of sweepers may be kept in abeyance.
What
So,
is
my-
DFS?
Department of
Finance,
Financial
sir.
Services, Ministry of Finance.
So you have already applied for.
Yes, so what is that
What is the
clarification?
clarification?
If
Yes.
there no clarification has come, then that means that it will not have any impact on the pending recruitment process. Because
What clarification is there? What is the clarification?
your lordship, till date, no clarification has been given to us.
so if no clarification has come from 2016, we are in 2023, it is 7 years. So my lord, there is no clarification to hold that the recruitment process had to be stopped because of this.
Yes, but the question is, what will be the procedure for the recruitment process?
So
It
after
has-
31/12/2016, not by interview.
Before that,
Before that, because my understanding of the word discontinuation is one can discontinue something which is yet to happen, which has already happened. Can it be discontinued, madam? Then it would have indicated in the advisory itself that this process of selection will also apply in all the pending recruitment cases.
Hmm.
So, in absence of any such instruction or indication to hold that this circular will apply in the pending recruitment cases, my lord, in my respectful submission, is not possible. And the 1990 judgment is very clear, my lord. If during pendency of any recruitment process, some changes are brought in, then those changes will apply to the pending cases only when there is a clear intention or indication in the amendment that it will have a retrospective effect. My lord, the same.
that is what I read from the circular. That you stop it. Stop the process of selection by interview
Stop, my lord,
with the outer limit of 31/12,
Stop.
31/12.
my lord, for a moment, Lord, excuse me, my lord. What can be stopped?
Process of interview.
Yes, that is yet to take place. What has already taken place? That is the interview. If the interview has already taken place, can anything which has already taken place be stopped?
Let me rephrase. Stop the process of selection through interview.
Yes,
So your selection was not complete because the results were never declared.
stopping selecting people by way of interview was taken on
On a date
November
prior,
2015.
on a prior date.
No, not on a prior date. The interviews were already over when this decision was taken.
Exactly.
So,
Hmm.
my lord, you stop this. You stop and you stop these letters by 31/12/2015. So from 15,
No, no, you are
31/12.
emphasizing on the interviews. You see, you cannot emphasize the interviews only on the interviews, because then the interpretation is what you project to be. You see, what has been stopped, what has been advised is that you change your process of selection.
yes,
Earlier it was interview, now you go for written
Exactly.
test, etc.
other thing, and you change by 31/12. So, meaning thereby that they have to take a fresh decision and amend the policy. recruitment
That's right.
policy.
That is what they have not done.
My lord, they have not done this one aspect. So, in terms of this advisory, they were supposed to change the recruitment policy. Now, if your lordship goes to this judgment, Supreme Court says, if any amendment is brought in the policy of recruitment, then that amendment will not apply to the pending selection unless that amendment clearly reflects. Lordship may have a look at paragraph 13.
मिला नहीं मेरा iPad लेके
My lord, for the timing, I am giving you. Paragraph 13, my lord. The same view was taken in P. Ganesh Rao of the state of Andhra Pradesh. Similar view was taken in so and so. It is well accepted principle of construction. Has the lordship got it?
yes
Paragraph 13, last paragraph. It is well established principle of construction that a statutory rule or government order is prospective in nature, unless it is expressly or by necessary implication made to have retrospective effect. Where proceedings are initiated for selection by issuing advertisement.
there are subsequent judgments, Mr. Chakraborty. I will request you to pursue it in later judgments where this principle has been watered down. Later judgments this year, last year, there are judgments
Which says
where the principle that you cannot change it is dependent on the facts and circumstances of each case. So the earlier principle that once you commence, you cannot change it has been watered down.
no, not changing. Here, this judgment says that
This is your claim. Your claim is once
can
you have
change,
once you have embarked, the interviews are concluded. Now you cannot say that the policy has been changed because it is effective from 31st of December. That is your claim.
in
Or
that case, my lord.
isn't that your claim?
My lord?
That is your claim, isn't it? That is your submission.
Yeah.
That once the interviews are completed, post 31/12, you change it, no problem. But before that, you cannot say that you have stalled the interview on the basis of this circular.
But if you want to change the recruitment policy, then your recruitment policy must clearly reflect that this amended policy will have a retrospective effect. Without indicating any such thing, can you apply a amended policy in respect of an interview which was
ना मिले लो। यहाँ रख दीजिए। Yes,
now that recruitment, that amended policy must give a reflection that it will operate from an
I'll request both councils to come up a little updated because there are subsequent judgments. We'll wait
my
for a
lord,
day.
so for this, one aspect is, my lord, this issue is pending before the constitution or a larger way. It is pending, but it
But
is
there are subsequent judgments also.
judgment, but the judgment can be, this judgment can be held to be a bad law only by a larger bench.
Then we'll
Till,
defer it.
no, my lord, till that day, for a lordship to
What-
say
what
this
I
is
am-
not a correct law.
No. I'm not saying this is not a correct law. I am not the one to say that. The apex court has watered down the principle. That is what I'm saying. So those judgments you'll have to rely on, refer to.
That has
You-
not come from any side till now, my lord. He has not placed on record.
I'm, as a council, you are entitled to rely on it also. As a council, to assist the court, you are also entitled to rely on it. Or if you want us to do it, we'll do it. Then we'll have to take it up on maybe 7th. 7th, we'll take it up. Because on this principle, I'm not with you. That this circular will not have a retrospective effect and therefore the interview is completed. Therefore, you have a vested right for appointment. I find it difficult to accept. Let me be candid with that. But having said that, fact remains that you have embarked on a policy for selection. You have said that we are going to change it. You have not changed that. You have shot some letter before the department. And for how many years? 7 years you are sitting.
7 months.
Instead, what you're doing, you're employing them, extracting services on a daily wage. You're not even releasing their minimum scale.
So
This
as
is
on date,
atrocious.
As on date, what is the policy? Okay,
This is
my-
atrocious.
My lord, as on date, what is the policy? If we do not know.
You are playing
what
with
is
the lives of the people. If you don't want, then discard them. You're not coming clear with your policies.
Your Lordship,
As on date, there is, apart from the 2007 policy, which I, on the last day I have placed before Lordship, there is nothing. Even this 2016 policy, my lord, nothing is stated about the sweepers. If we go by the board resolution taken by the Allahabad Bank, sweepers are excluded, my lord. The decision.
Yes, sorry.
I have given on the last occasion the policy of recruitment as far as the sweepers are concerned in Allahabad. Now they have come up with a policy of Indian Bank where we do not know what policy is applied for the sweepers. And going by the board's resolution of Allahabad Bank, it appears that they have decided to amend the recruitment policy of clerks and sub-staff excluding sweepers. So meaning thereby, sweepers in general do not come within the category of sub-staff.
but housekeeping is mentioned.
My lord, they have filed an affidavit.
You just give us one clear answer. Why are you extracting their services on a daily wage basis? What other cadre or staffs are working on a daily wage basis?
No, there is no other.
No
Your Lordship, what was happened, suppose today I required some cleaning, then only we will do it. Otherwise, it,
You
That
give
means-
it to, you outsource it to
He's trying to
service
say-
providers like that? You outsource it to service providers?
Can a branch run without a sweeper, my lord? We'll do the job. Now, whenever need means, we'll do the job of cleaning the branch, cleaning the toilets, which are mandatory, my lord.
Your Lordship, in
What
Allahabad
is
Bank,
submitting?
there was a specific policy for the sweeper. But in the Indian Bank, it was not there.
It is not there, then all the more reason why you should have, because you are appointing these people without any policy. There is no recruitment. On what basis are you paying them their salary and from whose kitty?
Not salary, Your Lordship.
What are you paying them? Wages?
Yes, Your Lordship.
Whose money is it? Who has authorized you to release the bank's money? Bank's money is public money.
Yes, sir.
What basis? Without framing any principle, policies? All right, we'll go for further hearing. You are not coming clean. We are putting you to notice. You are not coming clean.
And there is no policy as on date.
You are merely continuing to extract services of people by saying the policy is pending before the government. No clarification required. Don't engage them. Don't engage them. We want your policy by the next date. What do you want to do?
I should bring out some concrete, from the board itself, Your Lordship.
Whatever you want to do, do it. We are keeping it on 14th,
My lord, 7th.
7th. All right, 7th.
Your Lordship, maybe on 14th.
No, every time, my lord, he keeps on saying all these things, my lord. This is an old matter from 2016, and we are hearing this matter for a long time, my lord. 14th, my lord, 14th, 15th,
Because Your
16th,
Lordship, 4th, 5th,
There's
and
some
6th is
holidays in
holiday,
between.
Your Lordship.
that holiday is not applicable in bank.
We don't know. We're just saying.
4th, 5th, and 6th is holiday. And
Holiday for the
I
High
have
Court.
some outside cases.
Holiday for the High Court, not for the bank.
No, I am not denying that, Mr. Lord. So I have some outside cases, Your Lord.
That is not a ground for adjournment. You are supposed to get the instructions, that's all. Where you want to go during holidays is
I
your
just
call.
pray, Your Lordship, that if it would be, I cannot,
7th, my lord.
Your Lordship.
Because
We are not, if you are not agreeable on a date, we are fixing it on 7th. Let it be on 7th.
my lord,
8 to 9.
May it please Lordship,
Very much.
this matter pertains to Indian RD department. And here, my lord, what happened? Batch of persons were appointed prior to 1993. The policy of the regulation of 1991 for 1993.
Pleadings are complete.
My lord,
Pleadings are complete.
have you filed the evidence?
Pleadings are complete.
We are yet to file an affidavit. We are yet to file an
2021, it
affidavit.
was
When do you want to file it?
2 weeks time will be granted, my lord.
2002, yeah? Last time also, I think there was an order of my lord, last opportunity was given to them. 2021 matter, my lord. No more times it was listed also.
What was the direction earlier by the court?
Hello?
What was the earlier direction of the court?
Earlier direction, my lord, starting from 2013, my lord, Lordship kindly see annexure A, page 14, 2013, judgment, my
Page number?
lord, page number 14, my lord, 14.
Yes.
Here, my lord, here the persons came, my lord, and ultimately there was a direction in absence of any counter affidavit filed by the respondent. Their stand in the matter is not reasonable. However, from the matters on record, it appears that there was a recommendation to regularize the service of the petitioners. In view of the above, represents dispose of response to pass the approved order, if not already passed, taking note of all the attending facts and circumstances in accordance with law. This was. Then, my lord, follow contempt.
What is in page number 16? Oh, that
16
is
is
contempt
contempt.
case.
Contempt case, my lord.
Yes.
My name appears, my lord, serial number 11, annexure B.
Then,
Then, my lord, again another judgment comes, my lord.
Hmm.
2015, my lord. Page 18.
yes.
My name appears here also, serial number 11. The detailed judgment by Lordship Ujjwal Bhuiya, quoting everything. Then my lord, paragraph 33, having regard to the above and considering all aspects of the matter, response more particularly, response number 1 is directed to finally decide case of the petitioners as processed in file number so and so, keeping in view the provisions of the Assam Panchayat Employees Provisional Act 1999 and the observation made therein in the above. Let the said decision be taken within a period of 3 months. That gone. Then order was passed, my lord.
Then,
Then again, my lord, there is another in 2017. Page 31. Ultimately, your lordship can come to page 50, my lord. In 60, my lord, 60. Annexure I.
hmm,
Approval of regulation of service of the work task persons under master workers. Government notification letter data PDS 14/9/2005. With reference to the above, I am to inform you that the proposal for regulation of the service of the Sri Sasi Saikyam and others was submitted by letter number so and so and so. The basis of the particulars submitted by the Secretary of Lakhimpur Mahkama Parishad then file number so and so dated 99, wherein the date of joining of service of Sakya was shown as 1/4/1993. There, after the service secretary, not talking about so and so, directly communicated the matter with government by letter or so and so to the government in that the date of joining of is due in duty of such as 1/3/1993, not 1/4. Substantiated by 1/4/90, substitute 1/4/93. Further, Secretary Mahkama Parishad has stated that due to typing error, his date of joining was shown to be 93. So he was appointed, he is appointed earlier, my lord, but he joined on 1/4/1993. There was a cut-off date.
Then
Then when nothing is happened. Still he is doing, he in service money, he is doing about 200 rupees. Minimum he is getting. Others have been regularized, my lord. Along with him, those except him, others have been regularized. And 54, you will also will find others have been regularized.
yes,
54
Just
annexed
a few points that I would like to point it out. First of all, my lord, finance has not been made a party in this writ petition. They're a necessary party because that particular department.
Past will
needs to
regularize
sanction.
them.
what has the department done?
My lord, as far as this particular petitioner is concerned, they have not annexed any appointment letter to find out whether they have been engaged against any sanction post. So they have been given the benefit of the Upen Das judgment, wherein if they have worked for more than 10 years against any non-sanctioned post, they'll be eligible only for the minimum pay scale. The question of regularization doesn't arise. And my learned senior is relying on the judgment passed in writ petition 902 of 2017, wherein he's not even a party. So I don't know how he's seeking the benefit of this judgment. He has been engaged against non-sanctioned post, so that's why he's just
After all, he
eligible.
always non-sanctioned.
The non-sanctioned will get the benefit of Upen Das, working for more than
At
10
least,
years. in
I
a
think my
non-sanctioned.
friend, if it was sanctioned post, then there is no question of coming to court.
Where is your appointment order? Is it here?
Appointment order, my lord,
Not annexed.
pastoral employer, according to work manner, they were engaged.
Hmm.
And it is admitted matter by the Jila Parishad also, his date of joining is 1/4/1993. So there is no dispute as such.
No,
So
no,
far my
you are
joining and
working, you are working as what, tax collector,
tax collector,
as a master roll worker.
master roll.
Commission basis, my lord. If my lord
No,
has
no,
a-
not commission, he is getting salary, not minimum salary.
So the fact that you are working as a master roll worker, there has to be some order.
Hello?
Shouldn't there be an appointment order that you are working as a master roll?
That
As
is
a
not,
tax collector.
my lord, but it is not denied. It is not denied so far. Even in the earlier writ petition also, they have not said that he is not working, but he is. Otherwise, how would they pay my salary? Minimum salary, some lump sum they are paying.
That is okay, but for you to base your claim, would you
Hello?
not have a copy of the order?
In those matter, the according to work matter, they were charged.
Anyway, but your letter at page 60 is a letter by the department.
Yes.
My lord, they have just talked about date of joining. They've not talked about date of joining, whether in a sanctioned post or a non-sanctioned post. There is no particular.
Kindly read the letter properly.
There was a discrepancy in the date of joining, my lord, by 1 month.
Where? In the proposal sent for regularization.
Regularization. But for that, I'll have to check the records. what the records are.
And my lord, further your lordship can check page number 25, paragraph 31 of the judgment.
You file your affidavit or records or whatever is necessary here.
My lord, I'll do this.
Works as employees are not appointed against sanction post, my lord. If they are appointed.
Or we'll call your officers if you don't get the records or the
I'll do the
instructions.
needful. I'll
It's
activate-
better they are here because we can quickly finish off the matters instead of giving adjournments to councils who are unable to get instructions. Why can't you get your instructions?
I'll do this.
Are they not cooperating with you? Are they not giving you instructions?
Yeah, waiting. File it shortly.
If they're not giving you instructions, you tell us. We'll find a way to get the instructions. Heard Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. M. Soikia, Learned Counsel. Petitioner, this writ petition has been filed with the petitioner claiming regularization in his services as a tax collector under the Lokhimpur Mahkuma Parishad. Stop. The petitioner claims to be working from 1/3/1993. However, his services have not been regularized. Several rounds of litigation has been resorted to by the petitioner. However, in spite of that, his services have not been regularized. Several orders have been passed in earlier rounds of litigation. His cases were considered. Ultimately, the department had forwarded a proposal for consideration of his prayer for regularization. Stop. However, in the same proposal sent, there appeared to be an error with regard to his date of joining. Stop. His date of joining, according to the records, was 1/3/1993. And in the proposal which was sent, it was shown to be 1/4/1993. The same was clarified by communication dated 31/10/2005, issued from the Office of the Director, PNRD. Stop. Learned Counsel, Learned Counsel for the petitioner submits that in spite of this letter being issued by the department, no orders are forthcoming from the appropriate department in the government issuing orders for regularization of the service. Where Mr. Henry Clerk, Standing Counsel, PNRD, submits that he be permitted some time to obtain the clear instructions in the matter. He prays for 3 weeks' time. Prayer is allowed. It is expected that the department will post the Learned Counsel with required instructions and may file an affidavit if so advised in the meantime. Matter be listed after 3 weeks.
2 weeks, my lord.
3 weeks, because if it comes, then you'll require you may require to respond to the counter affidavit. 3 weeks. We are not putting it in the order, but if we find that the instructions are not coming, we are calling the officers. We are making it clear to you.
This matter I am led by Senior Counsel Mr. U.K. Nair. The departmental proceeding we are challenging, my lord. Prisoner was removed from service. May I pray this matter be passed over for the time being, my lord?
Time being,
Yes, my lord.
who's for the Guwahati University?
What Standing Counsel is there, KN Chaudhary is also there, Senior Counsel, my lord.
Can be taken up in some other day, Your Lordship.
No, let it be for the time being, my lord.
All right, 2 o'clock.
Oblige.
Maybe not.
I4,
Miller, PS8, my lord, kindly.
page 8.
Yes.
Para 4 and 5, my lord. Lays the steps effected through the OC Bongaigaon police station on the sole respondent. It should be a Kolgasi place.
What did you state in your petition?
My petition is also corrected. Sole respondent of Kolgasi place.
Kolgosia.
Santun Nehar, so PS Kolgasi.
Who's for the
No, my
respondent?
lord. Sole respondent yet to be appear before this court. We could not take steps, my lord, due to
This IA has been filed by the petitioner seeking correction of the order dated 6/6/2023 passed in criminal petition 53 of 2023. It is submitted that at para 4 and para 5. Now, it is submitted that in the said order, the order was required to be communicated through the concerned OC. Stop. Inadvertently, in the order, the name of the police station was reflected as Bongaigaon Police Station when it should have been Kolgosia,
Kolgasi.
Kolgasia
Yes.
Police Station.
Yes.
Stop. And accordingly, the IA has been filed. Para. Learned. Who's for the PP is not here. You should call for
My
the.
lord, the PP is not required, my lord. It's sole respondent
But-
here.
That's all right. But in the order here, we had recorded the PP's name.
Actually, my lord,
Third, Mr. Ahmed, Learned Counsel for the petition, peruse the order as well as the IA and the accompanying criminal petition. We've seen that the direction ought to have been the direction for service of notice was through the concerned police station, which was wrongly reflected as Bongaigaon Police Station. Stop. This stands corrected. The police station referred to in the order dated 6/6/2023 shall be read as Kolgosia Police Station
Kolgasi.
instead of Bongaigaon Police Station. Stop. The copy of the order dated 6/6/2023 as well as a copy of the order passed in this IA. Copy of the order 6/6/23 passed in criminal petition so and so, as well as copy of the order dated so and so. Sorry, copy of the order passed in the present IA be communicated to the sole respondent through the OC Kolgosia Police Station. So, the IA accordingly stands allowed. This order shall be read together with order dated 6/6/2023 passed in criminal petition 53 of 2023. IA stands disposed in terms of the above.
Complex.
So I am appearing at number 6 on behalf of PN Srinivasan sir. Matter become infraction, my lordship.
Infractuous.
Yes.
Your name,
N Islam. N Islam.
Mr. N. Islam, appearing on behalf of the petitioner, submits that the writ petition has become infractuous. Therefore, the does not wish to press the writ petition. Petitioner does not wish to press the writ petition. Accordingly, writ petition stands dismissed as not pressed. Interim order, if any, stands again.
Heard it earlier. Records, Lordship, I have received some part of it, Lordship. Records are here, Lordship, but then the originals are not there, Lordship. With me.
We don't know whatever you want to publish, show us if there's
Lordship,
anything. Otherwise, we have heard the petition.
Lord.
You give us the record, whatever is there, we are closing the hearing.
Lord.
Third Learned Council. Anything else you want to say?
No.
Third Learned Councils for the parties. Reserved. The you prepare index and flag mark in the records and hand it over to the court master
Lord. I will do.
by tomorrow.
Lord.
The records which are produced in court by the respondent counsel will be handed over to the court master after proper indexing.
Like, matter may be part of the timing.
Let us begin the hearing. What is the matter?
But this is a regularization of services of the inspector of platform.
What to? You are there. Who's for the respondent? Where are the health? Where are the healthy people?
Lordship, in this case, Lordship, Mr. B. Gogoi is appearing. He is on lakes in port number 6. It's a medical admission matter, Lordship.
Whatever matter, how are we concerned? We are concerned with matters before our court.
Take it up after some time or fix it and
Why fix it? 2017
say,
matter.
Lordship,
After some time.
at 2, Lordship.
Is there only one counsel in health department? You should have more.
May I start with the
This
factual part?
matter is handled by Mr. B. Gogoi, Lordship. That is
All right, at 2.
Factual part, Lordship, may I start with?
At 2 o'clock,
Yes, sir.
we'll hear it at
I'll
2 o'clock.
inform him, Lordship.
I love.
Don't say Passover.
Lordship, brief. I may be allowed to bring the brief. I may be allowed to bring the brief. Lordship.
Yes. We had just passed over, we were informed that the health council is,
I'm sorry, my lord, I was in. If Lordship permits me, I can start.
we can begin, but the health department is not available.
Oh,
That is the whole problem. We have kept it at 2 p.m. subject to your convenience.
however,
Is the council available, madam?
No, Lordship, he is in port number 6.
given time. I can start, I'll take some time, my lord, in the meantime, my learned friend can come.
After some time, I'll inform him, Lordship. Not
So
at
what
2.
I can do, I can start.
Yes.
Lordship's kind permission.
All right.
Yes. The file. Oh, time lagim.
Yes.
My lord, may kindly have WPC 2812. No, no. The 3383. 2812 of 2017.
2812, yes.
Yes. Basically, my lord, pursuant to a scheme of the government, we are praying for regularization. And Lordship will kindly come to page 25, my lord.
So who are you in the first place?
I am a person who was appointed under regulation 3F.
Real. As
Real.
a
as a my lord drug inspector,
All right.
drug inspector in the health department. Page 25. Subject to discharge without notice and without assigning any reason thereof, the following persons are appointed temporarily and until further orders as inspector of drugs for a period of 4 months under regulation 3F of the APSC limitation of function regulation 1951 in the scale of pay of rupees so and so. Now the appointees should join their place of posting within 15 days from the date of issue of this notification, failing which appointment will be treated as cancelled. Now, my lord, will kindly see serial number 2, he is the petitioner here, my lord. And serial number 1, Purno Hindu Mudoi, he is the petitioner in the other case. Now, my lord, their appointments were, my lord, extended from time to time. Page 29 to 50, my lord, are the extension orders. I'll not trouble your lordship with that.
Under 3F.
Under 3F. Then, my lord, I was once transferred to Tezpur also at page 51. While I was rendering my lord services under 3F. If your lordship will kindly come to the last one, my lord. In the interest of public service, Pankaj Kakoti, Inspector of Drugs, Karimganj, is hereby transferred and posted in the same capacity as Tezpur with effect from the date of handing over charge. Then, my lord, lordship knows there was a time when there were some doubt expressed about the manner in which 3Fs were appointed. Therefore, my lord, the government of Assam came up with a decision that 3F appointments can be made only with the approval of the cabinet. That too in case of public interest. At page 53, my lord, is the cabinet approval. 53. Now, lordship knows normally in the cabinet memorandum they write lot many things, but the approval contains a 1 or 2 page. Now, here in this case, page 53, subject approval for appointment of drug inspector under regulation 3F of the APSC limitation and function regulation 19. In other words, my lord, the appointment of the petitioner had the sanction of the cabinet office. Now, thereafter, my lord, what had happened? Government of Assam came up with a scheme at page 55. And my humble submission is, my lord, I would like to enforce my rights flowing from this. This is where, my lord, my cause of action starts. Page 55.
Yes.
Various departments of government of Assam from time to time exercising power under regulation 3F of the APSC limitation of function regulation, henceforth referred to as regulation 3F, gave appointment to various candidates to tackle emergency situations faced by those departments. Many such candidates initially appointed for 4 months under regulation 3F are continuing in their services year after year in ad hoc manner without regularization. All these candidates have already crossed the upper age limit specified for appearing in the interview test held by APSC for the post that they are holding and therefore left with no chances to get regularized in the post. Evidently, this situation has arisen mainly due to unwarranted exercise of power of under regulation 3F by the department, failure on the part of the APSC to hold interviews in timely manner, and also failure on the part of the department to move APSC for regular recruitment. As communicated by the concerned department, all these regulation 3F appointees now under consideration are working in regular vacancies, mainly under various orders of the High Court and drawing their regular salaries as admissible. However, those cases where the incumbent concerned have not appeared the APSC test interview and those whose cases are sub judice are outside the purview of this law. My lord, 2 classes of 3F appointees were kept out of the purview of this. They are, my lord,
incumbent concerns have not appeared the APSC test interview. And secondly, basically those who are working on the orders of the court. These two class of my lord PF appointees were kept out of the purview of this scheme. My lord, the petitioners were not working on the orders of the court. There was no interim order until, my lord, in the present proceedings, we came in. And secondly, my lord, this post on which we are working were never advertised. That is our specific thing. Then, my lord, I'll read further. Government, after careful consideration of the matter, after taking into account of the views of the finance, judicial in the individual cases, the views offered by the Advocate General on the matter, and also observation of the Supreme Court in so and so, I have decided to lay down the following policy guidelines in matter of appointment under Regulation 3F and regularization of the existing 3F appointees as mentioned, so as to prevent emergence of any similar situation in future that may compel government to resort to such measure as this. Henceforth, no appointment shall be made under Regulation 3F without prior conference of the Personnel and Finance Department and with the approval of the Cabinet. As such proposal as cleared by the State Cabinet for appointment under 3F have to pass through all the steps as laid down in guideline dated 24. Any fresh appointment made under Regulation 3F after issue of this OM shall get only 2 extension of term and their service shall stand automatically terminated. Personnel B department shall communicate the date of termination while allowing extension of second term. After the department shall immediately work out the number of employees appointed under Regulation 3F working in the establishment under their control and take up with the APSC for advertisement of the post within 3 months from the date of issue of this OM with intimation to the Personnel B department. Personnel B department shall not allow any further extension of the term of any employee appointed under Regulation 3F which exceeds beyond 6 months from the date of issue of this OM and will take up the matter with each of the department and APSC for advertisement of such post within the stipulated time. There shall be no person appointed under Regulation 3F with effect from 1st day of December of 2015. Now, my lord, 6 is important. The list of the employees appointed under Regulation 3F who have been considered here as an exceptional case and one-time measure for regularization as appended at Annexure A and who have rendered services to the government varying from 9 years to 22 years shall be regularized with immediate effect subject to the condition. That means, my lord, the person who have worked between 9 years to 22 years, they will be regularized. Now, what are the conditions? Each employee shall be regularized against regular vacant post, which they are holding currently and drawing salaries thereof. Each department whose name have been figured in the Annexure A against the name of the employee shall examine and verify the case of the employees individually with reference to their eligibility in terms of the education and other qualifications as required at the time of their initial appointment in regard to the post that they are now holding. On such verification, the department will issue order of regularization with immediate effect on the strength of this order. On such regularization, such incumbent will be eligible for regular service benefit condition as laid down in the respective service. Seniority of the employees in their respective category will be counted with effect from the date of their regularization. Their past service may be counted only for the purpose of calculation of pensionary benefit and for no other purpose. This is thought to be done as an exceptional case and one-time measure and shall not be taken to recourse in future. So, my lord, this is the scheme under which, my lord, as a one-time measure, government wanted to regularize the services of the person who are working on 3F. Now, my lord, despite this scheme, when our case was not considered, my lord, we approached this honorable court in WPC number 338
No,
of 2015.
Pursuant to the scheme,
Yes,
in the scheme itself,
yes,
there was a list of
yes,
names.
yes, my lord. It starts from page 58.
So your name
My
was
name,
not.
our name does not figure. If you
No,
lordship will
this
kindly
is
come to page
this is
59.
pertaining to 3Fs in all departments.
Yes, different department. My lord, the page number 59, health and family welfare, name of only 2% appear. One Rafiqur Rahman and one Satyendra Prasad Borua. My lord, none appeared before the APSC and not even completed 9 years of time. So these 2%.
And how many persons were there in total in under the health?
With that, we do not know, but we were there, my lord.
How many in your group?
We are 2, my lord.
2 persons.
Yes, Mudoy and Pankaj Kotok. Now, my lord, when our cases were not considered, then we filed a writ petition. That is, my lord, WPC number 3383 of 15. At page 61 is the order. My lord will kindly come to page 62.
Yes.
There is an interim order, my lord. Having heard the learned counsel for the parties, it is hereby directed that one post of drug inspector shall be kept vacant until further order. So, my lord, similar order was passed in case of the other petitioner also. Right.
Yes.
My lord, during the pendency of this 3383 of 15, certain employees of the social welfare department were regularized. Then we moved this IA, my lord, at page 63. And if your lordship will kindly have the order at page 64. First subpara, Learned Senior Counsel submits that present petitioner is identically placed like the petitioners of so and therefore an order similar to the one dated so be passed in those cases is also warranted in the present case. Only difference being that in the present case, the concerned department is health and family welfare in place of social welfare. Learned Standing Council has no objection to the prayer. Having regard to the above, the order dated 24 to 2016 passed in the above 3 cases would also be applicable in case of the petitioner. Let Health and Family Welfare Department take necessary decision on the office memorandum dated 16/3/15 and the outcome of such decisions to be informed to the court. It is expected that decisions so taken by the Health and Family Welfare Department shall be placed before the court on the next day. Then, my lord, this order was passed, which is under challenge in the present case. At page 66. Meanwhile, my lord, in the social welfare department, actually whom we are also representing, their services have been regular. Now, my lord will kindly come to page 66. Whereas Purno Sindhu Mudoy and Pankaj Kotoki were appointed as inspector of drugs, white HLA dated under regulation 3F, and tenure of their services were extended from time to time. Whereas Purno Sindhu Mudoy and Pankaj Kakoti have filed 2 separate writ petitions, respectively in the Honorable High Court, seeking intervention of the Honorable Court in the matter of regularization of their service. Whereas Honorable Guwahati High Court by 2 separate orders directed government in the health and family welfare to keep one post vacant under the further orders while referring to the personnel department, OM detention. Department took steps accordingly by not sending 2 number of posts to APSC for regular appointment. Whereas Honorable High Court on 3/33/16 passed 2 orders directing Health and Family Welfare Department to take decision on the basis of Personnel Department's OM detention regarding regularization of service of the aforesaid to Inspector of Drugs and to let the court know about the decision. Whereas Personnel Department advised the matter as follows. The normal procedure is that department should examine the matter case to case basis and take up with APSC for advertisement of the post for a regular appointment. Regularization through cabinet approval is not normal procedure, which should be adopted only as the last resort, and that too when there remains no alternative. Second note, that is 13, 12, 16. Subject to fulfillment of condition as stipulated by this department, OM dated so and so, tendered in your file number so and so, and following latest judgment ruling of the apex court as may be relevant, Personnel B department conveys its no objection to the proposal subject to the condition that incumbents are qualified and overaged, and that there is no scope for appearing before any interview to be conducted by APS. Now, my lord, the personnel B department in their note dated 13, 12, 16 conveyed their in principle no objection, but my lord, they added two riders. The two riders are that the incumbent is not overaged, and secondly, there is no scope of appearing before any interview to be conducted by APS. In other words, my lord, what the personnel department is visualizing is normally a person who is overaged, he can participate in a selection process. And secondly, the one who there is no scope of appearing in any APSC selection because AP has not advertised the post. In those two situations only, personnel department gave their view. Now, I'll show, my lord, why this is not permissible in this case. Whereas there are no records available to indicate that Purnakindu Mudoi and Pankaj Kotak were appointed after the posts were advertised for open competition. Whereas the condition given by personnel department wide note dated are in line with the condition laid down in the personnel department OM dated 1630. It is absolutely not correct, my lord. I'll show from this. Honorable High Court had directed department to take a decision based on state OM. Whereas it was examined in the department whether following conditions laid down by personnel department for consideration of regularization were made by Purna Hindu Mudoi and Pankaj Kotoki. The following are the findings. Whether the candidates are overaged. As overaged incumbents are eligible for consideration regularization as per OM. Present age limit is 43 years for the government employment for a general category candidate as per personnel department OM dated so and so, rate with OM dated so and so, which is relaxable by further 5 years in case of ST/ST candidates. The age of Purna Hindu Mudoi and Pankaj Kakoti as on 1/1/17 are 37 years 3 months and 39 years 5 months. Further, Purna Hindu Mudoi belongs to scheduled caste category. Thus, the incumbents are not overaged. So, my lord, one of the ground on which our case was, rejected was we are not overaged. I do not know where from they got it, my lord, that only overaged persons can be, my lord, regularized.
Where is that personnel department's,
My lord.
where is that personnel department's view or relaxation?
No, my lord. Anyway, my lord, I'll come to that. My humble submission is, my lord, this will not even come because 16.315 we are claiming right under 16.315, under which many have been regularized. Now they are bringing in so many things. The order passed in the earlier writ petition and then more particularly in the IA was to consider our case having regard to the, my lord, conditions laid down in 16.315 at page 56. So nothing to do with all this. Then let us read 2, my lord. Whether incumbents have appeared in APSC test interview as incumbent who have not appeared in APSC interview or outside purview of post. Presently, the advertisement issued by the APSC for the post of inspector of drug issued by the APSC was cancelled and it is proposed to issue a fresh advertisement soon. Thus, it is concluded that Purna Hindu Mudoi and Pankaj Kakoti have not appeared in the APSC test interview, whereas it emerges that Purna Hindu Mudoi and Pankaj Kotoki do not inter alia fulfill two major eligibility conditions laid down in personnel department's OM dated 20. Now, my lord will kindly come to page 56. Let us see, my lord, whether these two conditions are there in 16350. Please come to page 56, my lord. The list of employees appointed under regulation 3F who have been considered here as exceptional case and one-time measure for regularization as appended in Annexure A and who have rendered services to the government varying from 9 to 20 years shall be regularized His department whose names have been figured in the Annexure A against name of the employees shall examine and verify the case of each employee individually with reference to their eligibility in terms of education and other qualification as required at the time of their initial appointment in regard to the post that they are now holding. On such verification, department will issue order of regularization with immediate effect on the strength of this OM. On such regularization, such incumbent will be eligible for regular service benefit. The seniority of the employee in the respective cadre will be counted with effect from past service may be counted only for. Where are those conditions, my lord? Over this is 16.3. Under these, you have, already regularized 90, 90. And when it comes to us, my lord, you are saying we have not followed the two conditions as laid down in 16.3.2015. 16.3.2015 does not lay down any such condition. My lord, like ostrich, my lord, refusing to see the reality. My lord, my humble submission is, my lord, even otherwise these two grounds are not, my lord. My lord, the government of Assam had issued those age circulars. Those have been struck down by this honorable court. Because Lordship knows, as far as condonation of age is concerned, there is a circular OM issued by the government of Assam on, my lord, 3/5/1951 under Article 309. And Lordship knows, when a field is covered by notification under 309, then, my lord, by an executive instruction, neither you can override, neither you can supplement, you cannot do anything. So there are two judgments of this honorable court, my lord. Two learned single judge of this honorable court has struck down those, my lord, sir. And secondly, my lord, admittedly, this post were never advertised. In fact, my lord, I can indicate my lord, I would like to articulate my arguments, my lord. This OM dated P316 and 26/9/16, which pertain to this age relaxation, they are not applicable, my lord, because our case is concerned by 2015 OM. Therefore, this, OM will apply to, my lord, cases prospectively, not retrospectively. And, my lord, our case falls under 16.3.15, under which there is no requirement that incumbents should be overaged. 90 incumbents who got the benefit under 16.3.15 are not overaged, my lord. That is not above 38 years of age. The second ground, that petitioner did not participate in the selection process, is also misconceived. As a matter of fact, in the last 12 years, my lord, the APSC did not advertise the post. As such, the question of we having not participated in the selection process does not arise.
Yes.
This is my submission, my lord. If my learned friend also tries to develop an argument based on Uma Devi, then I have my reply, my lord. In reply, I will place all my judgment. I have come out with all the case laws. Very often, my lord, it is sought to be contended that because of Uma Devi, there cannot be any regularization. With respect, I will submit, my lord. As far as Uma Devi is
No,
concerned,
your claim is regularization as was done to these people
Yes,
in the 16 March? Or is it a claim that your name ought to have been included in
Yes.
16 March? Which one?
under Health and Family Welfare Department.
Is it your case that 16 March was issued for someone else?
Yes,
In the similar lines,
yes, we are similar, identically placed because we have also completed more than 9 years.
so another policy or order like that should have been issued?
No, actually, my lord, we
Or
should
is
have
it your case that your name ought to have been
ought to
included?
have been included.
So therefore, there is no scope for Uma Devi otherwise.
Yes. No, sir.
That is what I want.
No, my lord, even if my learned
Ah.
friend says
Because this is a decision taken by the government at
government.
the highest level.
So all that I'm saying, no, that's why I'm bringing in Uma Devi, my lord. Often, my lord, an argument comes from the other side that regularization after Uma Devi is not permissible. In my humble understanding, my lord, that's absolutely a wrong concept, my lord, because the Honorable Apex Court in that Jammu and Kashmir case and so many other cases has explained, my lord, the power of the executive cannot be taken away by the court, my lord. Yes, rather it is a restraint on the power of the court to issue direction for regularization.
Yes.
But as far as government is concerned, just one paragraph, my lord. If your lordship would kindly have this 2017 3 SDDS. I think one volume was given, my lord. 2017 3 SCC 410. At page 121 of the compilation.
Compilation.
Page number
Page number 410.
410 compilation.
Of my compilation which I've given. The 410 of the judgment,
Oh,
page 121 of the compilation.
yes. Yes.
One second. Para 19. So kindly give me 1 minute time. My lord will kindly come to para 19 at page 140. The judgment in Renu does not preclude, as a principle of law, the framing of an appropriate scheme of regularization in appropriate situation, meeting the norms spelled out into Uma Devi, and decisions which have been followed. Then my lord will kindly come to paragraph. One second, madam. Para 17 maybe. My lord will kindly come to para 26. One second, my lord. तेरी का मूल judgment to what question to 11. No, no. And I'll find it out where in the judgment Honorable Supreme Court says, my lord, that power of the executive has not been taken. It is always there. Because end of the day, my lord, in the exigencies of service, what particular decision is required to be taken, that is always the preserve of the executive, my lord. As has been said in para 19, my lord. Yeah, 51. Oh, yeah. Anyway, my lord, what I was trying to submit for lordship's kind consideration is, my lord, that there is a scheme. That scheme has been, my lord, given effect to. And our prayer is, my lord, since we are identically placed, therefore our case should have been included. By not including our case, as I've already indicated, my lord, the two persons, they are neither overaged nor they participated in any APC selection. Therefore, they could not have been included. That being the position, my lord, in my humble submission, my lord, lordships will interfere with the order impugned in this proceeding and remand the matter to the authority, my lord. They should consider in terms of
What is your present status today?
today I am working as 3F.
3F.
Yes.
Now, under the rules, what is the prescription under the rules?
Normally, my lord, direct recruitment.
No, under this 3F, limitation of function.
Oh.
So it has to be renewed, extended.
No, actually, my lord, this is intended to be only for 4 months.
Exactly.
And during that 4 months, my lord, if the authority comes to the conclusion that the post is required, then they should advertise the post, my lord. And the selection should be made to the public service.
So therefore, your claim only is that in view of a decision taken at the highest level, in that 16.3 order, your name ought to have been included.
That is
Now,
only case.
the further expansion of that interpretation to say that these two conditions are not applicable
No.
to you on a prima facie perusal of the order
The OM does not.
does not
indicate.
reflect.
That is my case. Subject to what my learned friends say.
Yes,
So far as the present petition is concerned, my lord, the prayer is confined to the, my lord, fact that, my lord, they should be considered for regularization as per this OM dated 16th of March 2015. Otherwise, my lord, in general,
not
if they-
consideration. Their name ought to
regulation.
have been included.
no, lordship may see the prayer, my lord. Prayer at page 22, prayer number 3, WPC 2812 of 2017. Editing the nature of mandamus and or any other writ of like nature to be issued, directing the respondent authorities to take proper steps to regularize the services of the petitioner in terms of the office memorandum dated 20. Not for inclusion, but they want that, man, of the benefit of this particular OM of 2015 should be given to them. And admittedly, my lord, both are, my lord, 3F appointed. And they are continuing in that particular post because of the interim orders of protection given by the Honorable Court in 2015. That they should not be.
Now, let us go back to that 16.3 order.
Not good.
16.3 was taken by the government to include
Yes.
3F workers in
It's
across.
a
the
one-time
state.
measure, lordship, that word has been used.
No, one time.
Yes.
What I want to know is in that one time, why their names were not included.
Two grounds, my lord, already we have, it has been pointed out in the Honorable Court in the speaking order that we have mentioned.
No, but
One is age bar.
these two grounds are not
No, I will
discernible.
point out, my lord. I will point out. Second is, my lord, that despite having several opportunities to participate in APSC selection, they have not participated. This is one ground, another ground in the OMN.
So selection means regular selection.
Yes. CF appointee doesn't mean that you will continue as CF appointee, thereafter you will be regularized as after serving for a particular period of time. My lord. In fact, my lord, there are judgment of this Honorable Court.
Take us through the rules of this limitation of function.
And says, my lord, when an appointment is to be made by direct recruitment to a temporary post created in a service, if it is necessary in the public interest, that the appointment should be made immediately, and reference to the commission would cause undue delay, provided that if the post has been sanctioned for or is likely to last for more than 4 months, the commission shall, as soon as possible, be consulted in all matters mentioned in subclause 3 of Article 320 of the Constitution. Well, it's for a temporary manner, stopgap arrangement manner. The person can be appointed in a sanctioned post for a temporary period of 4 months. And even my lord, nowhere it has been mentioned that it can be extended further. Be there as it may, my lord, the petitioners were, my lord, herein. They were appointed, my lord, under 3F, regulation 3F, and till date they are continuing. The lordship may kindly have a look at this OM at page 55.
85,
55,
55.
yes, in WPC 281
Yes.
of 2017.
Yes.
May I read, my lord, the first 4 paragraphs, madam?
Hmm.
Various departments of Government of Assam from time to time exercising power under regulation 3F of the APSC limitation of functions regulation, henceforth referred to as regulation 3F, gave appointments to various candidates to tackle emergency situations faced by those departments. Many such candidates, initially appointed for 4 months under regulation 3F, are continuing in services year after year in an ad hoc manner without regularization. All these candidates have already crossed the, lordship will see, all these candidates have already crossed the upper age limit specified for appearing in the interview test held by the APSC for the post that they are holding, and therefore left with no chance to get regularized in the post. Here regularized means by participating in the APSC exam or selection manner. But they, because of their age bar, they are not in a position to even participate in such a selection process. So the age factor comes in this particular para. Then third para, evidently, this situation has arisen mainly due to unwarranted exercise of power under regulation 3F by the department, failure on the part of the APSC to hold interviews in timely manner, and also the failure on the part of the departments to move APSC for regular recruitment. As communicated by the concerned department, all these 3F appointees now under consideration are working in regular vacancies, mainly under various orders of the Honorable Court, and drawing their regular salaries as admissible. However, those cases where the incumbent concerned have not appeared in the APSC test or interview, and those whose cases are sub judice are outside the purview of this OM. So, my lord, this is the second condition. Otherwise, well, it has been discussed. Government, after careful consideration of the matter, after taking into account of the views of the Finance and Judicial Department in individual cases, the views offered by the Advocate General Assam on the matter, and also the observation of the Supreme Court in so and so, have decided to lay down the following policy guidelines in the matter of appointment under regulation 3F and regularization of existing 3F appointees as aforementioned, so as to prevent emergence of any similar situation in future that may compel government to resort to such measure as this. So, my lord, these are the conditions. Now, lordship may kindly have a look at the affidavit, my lord. One para, my lord, it will cover both the cases. In fact, all the cases. The affidavit, my lord, filed in the incident case by respondent number 3,
Saurabh Senapati.
my lord. The relevant para will be, my lord, para 12.
Yes.
Here, my lord, the deponent makes the contention of the petitioner that there is no any clause, condition in the office memorandum dated 16th of March 2015, under which the petitioner is claiming regularization of service which mandates that the petitioner is overage is denied. In fact, it is clearly stated in the second para of the same memorandum that many such, well, that part I've already placed. The next para, further in the fourth para of the said OM, it is stated that however those cases where the incumbent have not appeared in the APSC test interview and those whose cases are sub judice are outside the purview of this OM. The petitioner has made a baseless contention that the Personnel Department OM dated 3/3/2016 read with Corriendum dated 26/9/2016 regarding relaxation of upper age limit for government job is not applicable to the matter of regularization of the petitioner. Since the Honorable Court in its order dated 15/5/2017 had directed the Health and Family Department to take a decision on the basis of the Personnel Department OM dated 16/3/2015. The Personnel Department OM dated 3/3/2016 only specifies applicable age limit, while the OM dated 16/3/2015 stipulates that a candidate has to be overage for being considered for regularization. Thus, OM dated 3/3/2016 only supplements the OM dated 2015, and there is no contradiction or conflict between the two OMs. In this connection, the Personnel Department endorsement dated 13/12/2016 on the matter of regularization is produced herein below. Subject to the condition that the incumbents are qualified and overage, and that there is no scope for appearing before any interview to be conducted by APS. Thus, Personnel Department has also reiterated the fact that for consideration of regularization, the incumbent must be overage, and there must be no scope for appearing in the recruitment process for regular appointment. The date of birth of the petitioner, as per available record, is 1/8/1977. As such, his age as on the date of issue of Personnel Department's OM dated 16/3/2015 is calculated to be 37 years, 7 months, and 15 days, whereas the upper age limit on the date of issue of the OM dated 16/3/2015 was 38 years. Further, the age of the petitioner on the date of issue of the Health and Family Welfare Department order dated 25/4/2017, rejecting the claim of the petitioner for regularization was 39 years, 8 months, 24 days, whereas the upper age limit for government recruitment was 43 years using the period from 3/3/16 till 3/2/3/18 by virtue of Personnel Department's orientated pension. Since the petitioner was not overage, we should have made him eligible for consideration of regularization of his service either on the date of Personnel Department OM dated 6/3/15 or on the date of Health Department order dated 5/25/4/2017. In fact, when a proposal was moved by the Health and Family Department Personnel Department on 13/4/2015 for regularization of service of the petitioner, Sri Pankaj Kakoti, the Personnel Department by endorsement dated 25/2015 did not convey its concurrence and advice as follows. The department is advised to take steps to advertise the post immediately. It is pertinent that the aforesaid advice of the Personnel Department was issued after the Personnel Department had already issued the OM dated 16/3/2015, stipulating the norms for regularization of 3F appointees, which clearly implies that the petitioner did not fulfill the criteria for regularization. Now, my lord, para 13. The deponent basis stated the contention of the petitioner that the Assam Public Service Commission did not issue advertisement for the post of Inspector of Drugs during these long 12 years is factually incorrect. The Health and Family Department, by letter dated 27/2016, had forwarded a draft advertisement for recruitment of 12 numbers of Inspector of Drugs to the Assam Public Service Commission. Accordingly, APSC published the advertisement dated 26/10/2015. It appears from the submission of the petitioner before the Honorable Court that he did not submit application for recruitment against the advertisement for recruitment of Inspector of Drugs by the Assam Public Service Commission published on 26/10/2016, although he was eligible. Although at a later stage the recruitment process was cancelled by Health Department's order dated 16/11/2016 in order to correct the qualification. The fact of the matter is that the petitioner deliberately chose to forego the opportunity of direct recruitment. Subsequently, the Medical and Health Recruitment Board
issued advertisement for recruitment of 12 numbers of Inspector of Drug on 21/2018. The age limit for applying to the state post as stipulated in the advertisement should not be less than 18 years and not more than 43 years as on 1/1/2018 as per Personnel Department OM dated 24. The age of the petitioner as on 1/1/2018 is calculated to be 40 years, 5 months and 0 days. And he was within the extent upper limit for applying to the Medical and Health Recruitment Board. Despite being eligible for applying to the Medical Health Recruitment Board for selection to the post of Inspector of Drugs, the petitioner refrained from applying to the state post, thereby deliberately foregoing the opportunity for regular appointment. The Personnel Department, in its endorsement dated 22 on the matter of regulation, has reiterated the condition that there is no scope for appearing before any interview to be conducted by APS. However, there was sufficient scope to participate in the recruitment process for regular appointment as shown in the following table, which has been deliberately foregone by the petitioner while claiming regularity. The advertisement numbers is age prescribed in the advertisement and the age of the petitioner is otherwise given in the chart. There are 14 melons. The opponent makes to state that the drug controller organization under Health and Family Welfare Department has been facing shortage of inspector of drugs. Direct recruitment process was delayed due to various factors. Therefore, in order to meet the shortfall of inspector of drugs, the government has resorted to TF on purely ad hoc and temporary basis. Since the regular recruitment could not take place, and in view of the resulting shortage of inspector of drugs, the department decided to extend the temporary services from time to time in larger public interest. But at no point of time there was any assurance given by the government that the services of the ad hoc employee would be regularized. Department is of the view that the regularization of the services of ad hoc temporary appointees who have deliberately chosen not to participate in competitive exams for direct recruitment would be a grave injustice to the candidate who aspire to participate in the recruitment process and get selected on the basis of their hard work and merit, as well as those who appeared in the recruitment process but were not selected. Such regularization would be very disheartening for prospective candidates. Sri Pankaj Kakoti, that is the petitioner herein, was appointed as Inspector of Drugs under Regulation 3F by notification dated 10/11/2005 for a period of 4 months only, in order to meet the urgent requirement of Inspector of Drugs. The State Cabinet, in its meeting held on 22/8/2006, had accorded ex post facto approval for appointment of Pankaj Kakoti as Inspector of Drugs.
What
under
happened to the earlier writ petition 3383?
Yes,
What happened to that writ petition?
pending.
Still pending.
It has come up today also. It has come up today, no?
Oh, this is
Yes.
part of the series.
Yes, it's part of the series. The State Cabinet meeting held on 22/8/2006 had accorded ex post facto approval for appointment of Sri Pankaj Kakoti as Inspector of Drugs under Regulation 3F of the APSC, Limitation of Functions Regulation 1951, subject to condition that the appointment should be valid only up to 31/12/2006, by which in the Health and Family Department would move the APSC for regular recruitment in accordance with concerned roster. The Personnel Department had communicated following views of the Cabinet memorandum prior to it being placed in the meeting of the State Cabinet. Personnel B Department have no objection to place the matter before the Cabinet for its ex post facto approval as proposed, but the department should take all
Any vacating petition filed by the respondents? Any vacating petition filed ever?
Only the state respondents are there, my lord, official respondents, nobody is filed. Regularization for government service by an ad hoc employee cannot be claimed as a matter of right, particularly when there was no such condition either during the initial ad hoc appointment.
So essentially, your submission
that
is
too
that
was there are-
the notification itself
Yeah, 2 and 4.
contains these two criteria, and therefore it was meant to cover only those category of
Yes, who
person.
are overage and who, my lord, despite participating in the APSC from time to time, could not, my lord, qualify.
Now, what do you intend to do with the petitioners?
That, my lord, otherwise, yes, my lord, they have continued for a long time. That, my lord, of course, my lord, not there with me, my lord, that inspector.
Because there are orders of this court. You have not filed any petition modifying the interim order or gone in appeal. They are working by virtue of the order of the court.
We are.
There is one
discussing the-
post kept vacant.
Yes, yes. Their post, my lord, which they are holding, those are sanction posts. That has been.
That has not been advertised.
It will not be advertised.
Yes, that is their case. Their case is
My
that
lord,
these
can I just
conditions are,
clarify one point, my lord?
yes.
My learned friend, please come to page 55 for a moment. Now, by reading the affidavit, my learned friend is trying to develop this point. Please come to the fourth subpart,
Yes,
page 55.
Yes.
As communicated by the concerned department, all these regulations we have appointees now under consideration are working in regular vacancies, mainly under various orders of the High Court, and drawing their regular salaries as admissible. Now, let me pause here for a moment, my lord. At this stage, on 16/3/15, my lord, we were not working on the orders of the High Court. Number one. Two. However, those cases where incumbent concerned have not appeared the APSC interview, and those whose cases are sub judice are outside the purview of this OM. My lord, what I have understood from this para is, my lord, those who have not applied to APSC, their cases will not be considered. And those who are working on the orders of the court, their cases will also not be considered. Now, my lord,
If you come to the second paragraph.
second, yes, my lord, whose cases are sub judice are outside the purview of this OM. Two categories of person. One, who have not appeared in the APSC selection.
No, I'm referring to the 16 March,
Yes, I'm.
second paragraph.
No, my lord, fourth subpara. Fourth subpara. Sentence starting with as communicated. The losses got in.
Yes,
As communicated by the concerned department, all these 3F appointees now under consideration are working in regular vacancies, mainly under various orders of the High Court, and drawing their regular salaries as admissible. Well, we never approached this honorable court on this day. However, those cases where incumbent concerned have not appeared the APSC interview, and those whose cases are sub judice are outside the purview of this court. That means, my lord, two categories of persons are outside the purview of OM. Number one, those who have not appeared in APSC selection, and secondly, those whose cases are sub judice before the honorable court. My lord, my learned friend has read the affidavit just now, my lord, and they have also given a chart regarding the position of advertisement. First advertisement was issued on night 2016, my lord.
no, let us come back to this subpara again.
Yes.
So there are, according to you, two conditions.
According to me, my lord, subject to what
Now-
Rosis may say, two classes of persons cannot be.
You're definitely not covered by the clause B that time.
No, no,
There was no case.
No.
Now, insofar as clause A is concerned,
yes,
uh,
we have
was
not.
there no occasion for you to appear before
Because
APSC?
there was no advertisement till then. My lord, first advertisement came in 2016.
Hmm.
Then in the affidavit, they themselves say, my lord, that advertisement was, my lord, recalled. On 21/18, when the advertisement was issued, I'm already overaged, my lord. My lord, this order, impugn order, which has been challenged in the subsequent petition, this reflects total non-application of mine, my lord. Where from this age comes then, my lord? Now they're talking about age. Does subpara 4 speaks of age, my lord?
No, but you have to read para 2 also, subpara 2.
Yes, my lord.
Subpara 2, if you read,
All these candidates have already crossed upper age limit specified for appearing in interview test for that post, and they are holding. No, my lord, that's true. My lord, this is only recited. Conditions are at page 56. On what condition their services would be regularized is at para Roman 6. What lordship has, what I have read from para 55, these are only recital, my. This is the background under which, my lord, this OM came to be issued. Even assuming, my lord, though it is a recital, but perhaps subparagraph 4, my lord, it does envisage two categories of persons who will not be considered. Number one, those who have not appeared in APSC selection, and secondly, whose cases were pending. This expressly says so, are outside the purview of this OM. So well, I do not fall in either category because there was no, from 2005 until 2018, there was no advertisement. We were recruited in 2005. Therefore, my humble submission is, my lord, the affidavit is also, my lord, they have done a mechanical exercise, my lord, just for the sake of opposing. They are doing. They are essentially saying two things. Number one, I am overaged. Second, we have not participated in the selection process. Where is the scope of participating? The first advertisement came in 2018. I am already overaged by then. And my lord, if your lordship will kindly come to our reply affidavit, I have explained that position. If your lordship will kindly take paragraph 5, my lord, of our reply.
Yes.
Page 3. That with regard to the statements made in paragraph number 8 of the affidavit in opposition, the deponent states that by OM dated 16th of March 15, policy guidelines in the matter of appointment under regulation 3F and regularization of the existing 3F employees had been laid down. A list as Annexure A was appended with the office memorandum dated 16th of March 15, wherein name of candidates and designation along with the name of the department of some person was reflected. In the said annexure, a total of 90 employees appointed under 3F were found eligible to be regularized in their service. In said annexure, a health and family welfare department stood as serial number 8 and name of 2 employees appointed under regulation 3F from the said department finds place in the list so prepared for regularization of the services. So far as applicability of the office memorandum to the incumbents who have not appeared in APSC test is concerned, the deponent states as follows. There are a number of incumbents who never appeared in APSC test interview and yet got the benefit of regularization under office memorandum. The person who stood at serial number 2 under the health and family welfare department never appeared in APSC test interview and yet got the benefit of regularization under the office memorandum.
But you're not challenging their regularization.
No, I'm not just saying, my lord. True.
So negative in equally.
No, my lord, I'm just pointing out.
Yes, yes.
No, end of the day, my lord, they have given 2 reasons. Number 1, I am overaged, and number 2, we have not taken part in any selection. Now, number 2 is concerned, my lord, out and out, it does not arise because advertisement came for the first time in 2018. So, my right accrues on 16/3/2015, even prior to this, because 16/3/15 takes note of facts which have preceded that. That means in the meanwhile, certain development have taken place. To address that issue, my lord, government came up with that OM. Therefore, my right precedes the date coming into force of the OM. Not, it will not follow. So therefore, if that be the position, my lord, there is no question of, my lord, either of the 2 considerations, my lord, coming into play. And my lord, those 2 OMs which speaks of 43 as it is, my lord, in terms of the order of this 2 judgment of this honorable court, those are no longer holding the field. And my lord, apparently, my lord, none of them has appeared in selection, yet their name finds place. Therefore, my third prayer is, my lord, that as in the, my lord, 16/3/15 OM, our case should be regularized. And till date from, my lord, 2015, 8 years, my lord, state has never filed any application seeking stay of the thing, my lord. And we are continuing.
Your appointment on the 3F was on 2005. 2005. And
Yes.
the advertisement was on?
First in 2018. There was a 16 advertisement that was abandoned. And my lord, there is one recent judgment of the Supreme Court, my lord. এখন দিয়ক না। Almost identical facts. kindly come to my lord, paragraph 3(4). The matter arises out of regularization of employee. Chief Commissioner of Income Tax in his report dated 14/2/2013 found that in exercise conducted in pursuance of a judgment of this court in Umadevi, those 65 employees are found to be entitled for regularization. Only 35 were regularized. This was done since only 35 vacancies were available. 16 persons out of remaining 30 employees filed contempt petition alleging that respondent department are not regularizing the services of the appellant, thereby committing contempt of court. It appears that before the High Court an affidavit has been filed stating therein that the service of the appellant could not be regularized since posts are not available. On this statement, contempt petition has been filed. In the Constitution Bench judgment of this court in Umadevi, though court had held that backdoor entries should not be permitted, it has permitted one-time measure to be conducted for regularization of service of employees who have completed of service of more than 10 years. Indisputably, appellants herein have completed service of more than 10 years. Even this court in so-and-so decided on found that the act of regular service of some employees and non-regularizing service of others is discriminatory and violative of Article 14 of the Constitution. Aishwarya Bhatti, learned additional Solicitor General, appearing on behalf of the respondent, have vehemently opposed the petition. She submits that since posts are not available, therefore, thereafter group the posts have been abolished, the appellants could not have been regularized. We are not inclined to accept this submission on behalf of the respondent. When Chief Commissioner of Income Tax has himself found that 65 persons are entitled to be regularized, the act of regularizing the service of 35 employees and not regularizing the service of others, including the appellant, is patently discriminatory and violative of Article 14 of the Constitution. If, my lord, the 2 persons from the list are entitled, we are also entitled because we have completed 10 years. Umadevi has not brought in all these considerations, my lord. Only consideration Umadevi brought in was 10 years service. And para 13, the services of appellants are directed to be regularized from the date on which services of other 35 employees are regularized, and back wages and other consequences benefits to which appellant shall be paid to them within a period of 6 months from today. And my lord, today, my lord, one of the petitioner is 44 years and other is 47 years.
What was your age in 2018?
2018, 40 years.
2018.
My lord, yes, the petitioner in 3383, date of birth is 1877. So in 2018, he was 41 years, my lord.
So why do you say you're overaged by that time?
Yes, my lord, 43, that circular can be held to be good because of the 2 judgments of this honorable court, my lord.
Was the judgment delivered
Yes, there are 2 judgments, not one.
prior to 2018?
Yes. My lord, 2015 4 GLT 103 and 2019 2 GLT 455.
2015?
4 GLT 103
and
2019 2 GLT 455. Because, my lord, that 51 circular will hold the field.
What was the finding here in the court in these 2 judgments?
That, my lord, this OMs of 16 on which they are relying, this could not have been there because if at all any age relaxation is to be given, it has to be given under that 51 OM, which is under Article 30.
By the governor,
By the government.
in the name of the governor.
My lord,
But post this judgment,
Yes.
There is, I've noted circulars extending the age limit,
No,
upper age limit.
my lord, honestly speaking, my lord, the judgment may not have been taken note of, but fact of the matter is there is a judgment of this honorable court. Lord,
Yes.
I forgot to bring to Lordship's notice one observation of Chief Justice in that judgment of Jammu and Kashmir matter. Please have the compilation at page 134. Part of para 11. Page 134 on top. This is the para which I wanted to, place before Lordship. However, as a Lordship's got in, my lord, Uma Devi is not an authority for the proposition that the executive or legislature cannot frame a scheme for regularization. Uma Devi does not denude the state or its instrumentalities from framing a scheme of regularization. Well, often it is said, my lord,
I think that has been clarified subsequently in
so many judgments.
judgment.
Therefore, my lord, my humble submission is, my lord, the two reasons.
But if is a proposition to say that don't go on repeated regularization, frame a scheme. One
Frame a same one time. In fact, my lord, Uma Devi and ML Keshari, these are the two judgments, my lord, where, my lord, it has been clearly. Anyway, my lord, coming to the facts of the present case, in my humble submission, my lord, two reasons cited by the government. Perhaps, my lord, it cannot appeal to your lordship for the simple reason. These are not relevant. Because, number one, my lord, they have committed an error in undertaking that one-time exercise of not taking note of everybody. They cannot just pick and choose, my lord. Apparently, my lord, we were left out, as now it transpired. So we were left out. So our right under Article 14 to have the benefit of that, OM has been denied. Now, my lord, now the state cannot come up with these additional grounds. Yes, it's a fact, my lord. We never approached any court of law until the present, litigation. And secondly, my lord,
No, but if the first advertisement was in 2018,
yes,
you had approached this court earlier in 2015, I think.
no, my lord, that's why I said, Lord will kindly appreciate one aspect of the matter.
Hmm.
My cause of action arises on account of events which have preceded 16/3/15. Lordships will not, refer my case to a situation post 16/3/15. Because my cause of action, in my humble submission, is, my lord, became ripe on the day notification was issued. On before that, let my learned friend show one advertisement, my lord, before 16/3/15, after I joined service.
What are your pleadings in so far as 3383 is concerned?
Yes,
3383.
same, my lord. He's also from the health department. Same order, my lord. Same impugn order.
See, while deciding matters pertaining to health department, we are putting our health at risk.
Sir, only one thing, my lord, I would like to add. In the writ petition,
Yes.
they have annexed one list of candidate persons who have been regularized pursuant to this OM of 2015.
Oh, 3383 of 15, my lord. On that, my lord, this we came for mandamus based on the
OM.
OM. Their pleading would be slightly
And there was
different.
a
So
order passed
therefore,
that, my lord.
that is what I wanted to see, that how are you agree? You are aggrieved by the OM. You are aggrieved by this OM, 16.3.
No, my lord,
Yes.
there was a direction given in between the, my lord, proceedings of
And
these
ba-
cases in 2015.
And based on our prayer, my lord, in the IA, a mandamus was issued to them to consider our case. Then they issued that order,
They're
which has
speaking
been,
order, in
which
between
has
they're
been
speaking order.
No,
challenged in the
therefore,
subsequent.
why are you aggrieved by 16.3?
We are not aggrieved, my lord. We wanted to have the benefit of, we
Ben-
want to enforce 16. We say our right flows
Okay,
from
okay,
16.
Yes,
That is
because your names are not included in the list.
Page 14, that's the prayer, my lord.
All right.
Now, my lord, the averment has been made, oral averment has been made before his honorable court. That, my lord, lordship may kindly turn to page 58. 58 and 59. This is the list of persons, my lord, who have been regularized pursuant to the above 2015. Now, my lord, the health department serial number comes at serial number 9. 9. There are 2 persons have been regularized. And oral averment has been made that, my lord, these 2 persons are also, my lord, they are neither overage nor they have participated in any APSC exam. My lord, going by the pleadings in the petition at para 11. Para 11, my lord. Page 59 is the chart. Relevant health department, 2 names are there. Research assistant, they have been regularized. And corresponding para to this annexure is para 11 at page 11 of the writ petition.
1 minute. Yes, you're referring to
My lord, para 11 at page 11 of the writ petition.
para 11,
Yes, 2812.
2812.
But it is in this entire para, there is not a single, my lord, averment on record that these 2 persons who have been regularized pursuant to the OM of 2015, they are neither overage nor, my lord, they have participated in any APSC exam.
Who?
These 2, my lord, persons who have been,
That is their claim.
no, that is their claim, but it should be on record, my lord. The oral submission will not do that. That's what I am
No, my lord,
submitting, my lord.
affidavit in reply, which I read just now, I have made a statement.
No,
And then if
reply
I have
also, my
missed it-
lord, I have not found, my lord. I would have pointed out that also.
No, see,
No, their contention is that, my lord,
the
though we have-
submission of the counsel for the petitioner is there all these conditions, all these mentions in the order of 15.3,
Yes, my lord.
sorry, 16.3
16.
are basically recitals to explain what led to the decision taken by the government. The conditions which are mentioned are
Page
detailed in
56.
the
That also may I clarify, madam.
Yes.
Just lordship may kindly turn to page 56 for a moment.
50,
56.
56. Yeah, 56.
Roman 6 para
Hmm.
that they were referring. The list of employees appointed under regulation 3F who have been considered here as an exceptional case and a one-time measure for regularization as appended at Annexure A and who have rendered service to the government varying from 9 years to 22 years shall be regularized with immediate effect subject to the condition. These are the conditions of regularization, not my lord the eligibility criteria for getting the benefit of this particular OM. Whoever is regularized, this will be their condition. Means those who have already been selected in list A appended to the OM.
What conditions can you append to for regularizing somebody?
My lord,
Regularizing means,
2 and para 4, I have already pointed out.
what is the meaning of regularization? The person is working on ad hoc.
Yeah.
You are regularizing services so that it
No,
becomes a
so
member of the cadre.
My lord, their criteria has been fixed, my lord. Not everybody can be regularized.
No, therefore, these
Yes,
are the
so say that, my lord,
conditions.
these are the criteria. It's not the criteria. These particular
Right,
para-
we'll use your term called conditions. These are the conditions for regularization.
not for regularization, my lord. If they are regularized, this will be the conditions they will give. My
It
lord.
cannot be.
Lords will read.
No, it cannot
my
be.
lord, may I
Then,
read the
no,
para,
no, no,
sub-para?
no, no. See, are you
List of
having,
employees,
Mr. Counsel, please listen to the question of the court.
my lord.
Once you regularize somebody,
Yes.
that person becomes a member of the
Yes,
regular
cadre.
cadre.
Yes.
Once you become a member of the regular cadre, you are governed by the service rules.
My lord.
Can you now have a set of different rules or conditions or OMs?
Lordship may kindly see, my lord, whether these are the eligibility criteria. Say it has been mentioned as condition, whether it can be termed as in that manner. One, each such employee shall be regularized against the regular vacant post which they are holding. So post regularization, what will be the post where they will be regularized? It has been mentioned. Not that, my lord, how to select the persons who will be regularized.
All right.
That is in para 2 and para 4. That's what I want to clarify. These are the conditions.
Para 2.
Para 2 means, my lord, in the first, my lord, that I have referred.
All right.
Page 55.
All right, we have heard.
Yes, these are the conditions, my lord.
We record your submission.
My lord.
Well, only one thing, my lord, in the first petition, para 14,
Hmm.
if my first read petition is allowed, my lord, lordship need not go to all this. Please come to page 12 of my first read petition, my lord, para 14.
Your first writ petition, you are challenging this.
No, we came.
You are seeking a direction for being included in terms of this.
Yes, that's what I'm, para 14, my lord.
But in the IA, there was a direction to consider
Consider
your
my
prayer
case.
and therefore the subsequent order has been passed.
Yes.
So technically speaking, your first writ petition has become infructuous. Perhaps.
Yes, sir. No, all that only one thing I want to just point out, my lord,
Hmm.
para 14.
Just 1 minute. Yes. In the earlier writ petition.
Yes. Page 12, para 14. That the petitioner begs to state that the petitioner begs to state that as the office memorandum bearing so dated 16th of March has been issued as an exceptional case and one-time measure and shall not be taken to recourse in future, therefore, all similarly situated persons should be included and covered by the state process of regularization as a one-time measure. It is stated that after publishing the office memorandum dated so, when petitioner saw that his name is not available in Annexure A appended to the office memorandum, then the petitioner filed a representation before the additional chief secretary personnel with a prayer to review the entire matter and also prayed to take necessary action for regularizing the service of the petitioner, and the representatives who submitted petitioner is left unable. That's why we had to come.
All right.
And my lord, regarding the other point, my lord, I have already indicated, my lord, in para 5 of my affidavit in reply, I have already indicated, my lord, why, my lord, that the other two persons could not have been included. Para 5, I have already. And then, my lord, will give a meaning to that poem dated 16/3/15, my lord. Everything hinges on that. One line of argument I have advanced, one line my learned friend has advanced.
My lord, one, my lord, para I would like to point out, of that, my lord, Jammu Kashmir judgment that has been referred to, I am holding that, my lord, Manupatra citation, it's in para 19. Though, my lord, it has been stated that, my lord, the state has the power to frame such policies to regularize, my lord, casual workers or ad hoc workers. But at the end of the para, Honorable Court has stated that, Apex Court has held that, my lord, the scheme or policy will have to be, my lord, in terms of the exception carved out in para 53 of Umadevi. That cannot be bypassed. That is, my lord, 5 judges bench order.
No. What
Finally, it has
what
been
we
submitted,
would like to understand is
my lord.
the decision to regularize, not to regularize is for the state.
Executive, yes.
But it will
It's
have
not
to
for
be
the court
following the
to
local
decide and tell
legislation,
you.
my lord.
If you don't want to regularize, you have your reason.
Lord.
But you can't say that we cannot regularize because of Umadevi. That is
So
the,
that's not the case here in my lord. Nowhere we
you
have
may
taken
have
that.
very good reasons for not regularizing.
But there is a policy, my lord, for regulation. Now, whether the petitioner fit in with to the, my
That
lord,
is,
yes,
that you have
conditions,
already
yes,
explained, so we'll
Well-
examine and pass an order on that.
my lord.
Deeply obliged.
Heard, reserved.
Deeply obliged.
Obliged, sir.
All the matters are similar matters.
Two persons, my lord, four written.
All-
Only petition, the speaking order is same for both, same
for-
common order,
for both.
impugn order.
May please, your lordship. May it please, your lordship. In this case, I'm led by senior counsel, Mr. Yuke, but some personal difficulty has been left. Lordship, so may I pray for an adjournment?
So I am for the respondent number 7.
What do you say? Why don't you come towards the podium? Why are you making a submission from so far away?
So I am for the respondent number 7. That
No, he is prayed for an adjournment.
Lordship.
What is the issue about?
Your lordship, the petitioners therein are the accounts officers. Now they are seeking a promotion to the cadre of PAO, that is finance and accounts officers. Now the issue was that there is a rule which governs the service condition. As per these rules, the minimum age should be 50.
Minimum age should be?
50. We participate. Now what happened when the APSC conducts the examination? We participated. And the private respondents herein were overaged. So the private respondents have been, their age were condoned by the APSC. Not only that, in the examinations, they are given the grace marks. We are not given the grace marks. Second issue is that there is,
Their age was not condoned.
Your lordship,
Was their age condoned?
yes, not only their age was
Who
condoned,
condoned it?
APSC.
How can APSC condone it?
That's one precise case. Secondly, not only that, they were given the grace marks. That is an
Grace
admitted question
marks.
by the APSC.
Hmm.
And third and most important thing, that grace mark was not given to us. And we belong to the reserve category candidate. One belongs to the SC category and the other belongs to the STP. In spite of there being a clear-cut vacancy for the SC and the STP, we were not accommodated. And we say the rules does not specify.
Pleadings are complete.
Yes, your lordship. Pleadings are complete means, your lordship, my friend has not filed any affidavit. He chose not to file any affidavit.
It's up to them. Are you
Yes.
filing any affidavit? No.
We rely on the affidavit file the APSC. Lordship.
Do not say that.
All right. We posted for hearing then. Pleadings, it is submitted that the respective parties have exchanged their pleadings. The matter is ripe for hearing, admit for hearing.
Your Lordship, the matter was already admitted for hearing by Justice K. Suran. There is
Okay.
an order.
All right.
May I plead
List-
that Your Lordship can the matter be listed next week if it's not inconvenient?
it will be listed in its own turn. Own turn. Fixing a date, because once the matter is not taken up today, it goes out of the, another date will have to be decided in
Instead
terms
of a
of the,
date, can it be next week? Instead of a date?
not next week, not next week. It will be after 2 weeks, after 3
that
weeks.
is fine. That is fine. with me.
All right.
Deeply obliged.
Hello.
Yes.
May I please? My lord, in this case, my lord, earlier, my lord, this respondent number 5, my
What
lord,
is
was-
the urgency here? 2020 matter,
My
then
lord,
whole
this is
matters
very
here.
urgent matter because
Why, what is the urgency?
urgency that, my lord, he was appointed, my lord, without qualification, my lord.
Who?
My lord, private respondent number 5, my lord.
As what?
To the post of Muslim marriage registrar and Qazi, my lord.
Very well, we'll decide on that.
Yes, my lord. Only thing is that, my lord,
No.
earlier, my lord, he was selected, my lord. And this, my lord, division bench, my lord, remanded the.
This matter is for hearing.
Yes, my lord.
All right, we'll take it up in its usual course. What is the
No,
urgency?
my lord, early hearing petition is also here, my lord.
Why?
Because, my lord, the matter is, my lord, initially it was provided to consider the interim prayer, my lord. But it was not
Lordship, my
considered.
lord, it is not correct, Lordship. Already, my lord, several occasions it was been hard. And only because of, my lord, this, the petitioner's mistake, my lord.
No, no, it is
When it
correct,
was, my lord, it was, my lord, CAV. After a long,
Oh, it was part heard.
Yes,
It was part heard before some court.
yes, my lord.
Then
After, my lord, there were, by it was kept in part heard, my lord, that the judgment was all reserved. After, my lord, that when the, my lord, that matter was, my lord, verified, that the respondent number 5, whose
No,
they were
this
put
is
the
my
respondent number 4.
my lord,
Huh?
my lord, what
They,
1 minute, let him submit. Let us, we'll hear you. Yes.
that they put them respondent number 4 instead of respondent number 5. Only because of that, my lord, incorrect, my lord, that putting the respondent number 4, that it has been, it cannot be, the judgment cannot be pronounced, my lord. It was deferred. Lord.
Then, my lord, I filed IA, my lord, and it was corrected, my lord. My lord,
The order dated 21
my lord, in the, my lord,
20,
petition, my lord, respondent number, my lord, 5 was referred as 4, my lord. Therefore, I filed, my lord, IA, my lord, and IA was allowed, my lord, and subsequently it is corrected, my lord. And everywhere now.
No,
is
it
fine,
was
my lord.
part heard. Was it released from part heard?
Yes, my lord. After part what, my lord, matter was gone to the even CAB, my lord.
Then?
But only judgment was, my lord, could not be pronounced, my lord, because, my lord, in the writ petition, my lord, in the body, my lord, respondent number 5 was referred as respondent number 4, my lord. Therefore, my lord, I had to file, my lord, one miscellaneous application, my lord. It was allowed, my lord, and it was corrected. And now, my lord, everywhere respondent number 5 is 5. My lord, matter is very small, my lord, because, my lord, even otherwise, my lord, only, my lord, division bench and then single bench provided, my lord, whether his qualification is, my lord, eligible for the post of, my lord, MMR and Qazi, my lord. And admittedly, my lord, they have not considered that, my lord. No hearing also taken place, my lord. In the, my lord, affidavit of the government, it is clearly stated, my lord, as per the order of the division bench, my lord, no hearing was taken place, my lord. Lordship, kindly have a look there, my lord. Therefore, my lord, in any case, my lord, permanent committee has to, my lord, receipt, my lord, and re-verify and pass fresh resolution. This is the case, my lord. As per my humble understanding, my lord, better than, my lord, this selection, my lord, earlier he was selected, my lord. Even then, my lord, this honorable court, my lord, division bench, my lord, interfered with the selection of the respondent number 5, my lord. That, my lord, it was not followed as per law, my lord. Therefore, my lord, matter was remanded back to the permanent committee, my lord, to receipt and reconsider, my lord. But even then, my lord, in the paragraph, my lord, 14, page 3 of their affidavit, my lord, clearly, my lord, they have admitted my grievance, my lord, that it was not considered.
Lordship, kindly will look there, my lord, earlier division bench order, my lord. Earlier his selection, my lord, page, my lord, 67, my lord.
No, earlier you raised this issue.
Yes, my lord.
Then what happened?
My lord, problem is what, my lord, I kindly may be allowed to say, my lord. My lord, I am directly, my lord, FM pass candidate, my lord. Madrasa final pass candidate from Assam, my lord. And he, my lord, submitted one certificate, my lord, that he passed, my lord, equivalent to FM, my lord, from UP, my lord, Rampur, my lord.
Hmm.
This is the crux of the, my lord, matter, my lord, my grievance, my lord. And my lord, rule is very clear. I have annexed also rule itself, my lord, where, my lord, there is no provision for equivalency, my lord. Directly, my lord, it is provided that, my lord, FM candidate like me, my lord, should be appointed, my lord. And if any other candidate having, my lord, law knowledge of, my lord, Muslim law, he can apply. But when I will come, my lord, then, my lord, I will get preference. The rule is very clear. Rule 4, my lord. I have annexed this rule itself, my lord. So he has, my lord, my humble understanding, my lord, he has no merit, my lord.
Where is the impugned order?
My lord, impugn order, my lord, page 36, my lord.
Where is the equivalence certificate?
My lord, his equivalency certificate, my lord, it is page, my lord, 30, my lord.
30.
30, my lord. This is also, my lord, contradictory to his, my lord, mark sheet. My lord, here it is provided that when a certified that the qualification of pass in the Fazil examination. Here it is provided, my lord, Fazil examination of government oriental
What
college.
are the rules of State Madrasa Board?
My lord,
Where are the rules?
my lord, I have annexed this rule, my lord, page, my lord, qualification required as per rule, my lord, 21, my lord. There is no provision of, my lord, equivalency, my lord.
Where are the rules?
Rules, my lord, page 21, annexure 1, my lord.
Page number 21.
21, my lord.
Yes. What rules are these? These are
District, my lord, rule, my lord, 3, my lord.
um,
Rule 3, page 23, my lord. The district registrar's nomination shall be submitted to the Inspector General of Registration to be placed before the permanent committee and shall be accompanied by the original application. Original application of the candidate in following form together with the certificate of good moral character and either a certificate that he has passed the Assam Senior Madrasa. I am first, my lord. Assam Senior Madrasa final examination. Or, my lord, a certificate that he possesses a sufficient acquaintance with the Arabic language and the Muslim law of marriage and divorce, signed by 3 Mohammedan gentlemen of respectability and position. So, my lord, he is being dragged, my lord, under this, my lord, certificate, my lord, that 3 gentlemen should sign, my lord. He is a knowledgeable person in, my lord, Muslim law, my lord. Under this provision, but ignore one last paragraph, my lord. Kindly see, here it is also provided, my lord, the certificate of, my lord,
permanent post of Muslim registrar will be preferred if they have passed the Assam Senior Madrasa final. Matter is ended here, my lord. Suppose, my lord, even he is, my lord, for the time being, assuming, my lord, he is qualified. As per this provision, my lord, he has some certificate having knowledge in Mohammedan law, my lord. But when, my lord, it is provided in the rule 4 clearly, that, my lord, when I will come, my lord, by any candidate will come with, my lord, FM pass, like me, my lord, my certificate, I have annexed, my lord, then he is out, my lord. Even then, my lord, he is selected, my lord, over me, my lord. And in this regard, my lord, time and again, this honorable court, my lord,
Let us go to the rules again.
rule, my lord, rule 23, my lord, kindly I may be allowed to read out.
Rule 23.
Sorry, rule 3, form of application. The district register nomination shall be submitted.
No, you come from rule 2 first.
Nomination of Muslim register. As soon as the act comes into force in any area, the district register shall nominate a sufficient number of persons possessing the qualifications as specified in Rule 3 to be licensed as Muslim register under Section 3. The district register shall also specify the limits within which each of the persons so nominated shall exercise the function of Muslim register. Rule 3, form of application. The district register's nomination shall be submitted to the Inspector General of Registration to be placed before the permanent committee and shall be accompanied by the original application of the candidate in the following form, together with a certificate of good moral character and either a certificate that he has passed the Assam Senior Madrasa final examination or a certificate that he possesses a sufficient acquaintance with the Arabic knowledge and the Muslim law of marriage and divorce, signed by 3 Mohammedan gentlemen of respectability and position. Application of Muslim registrarship under the Assam Act so and so of so and so, so and so, so and so. Then, my lord, rule 4, who may be nominated. Candidate for permanent post of Muslim registrar will be preferred if they have passed the Assam Senior Madrasa final examination and they must be of good moral character in the selection.
What is the meaning of rule 3 that he has passed the Assam Senior Madrasa final examination?
My lord.
Or
my lord.
what is the significance of this or?
Or, my lord, and if suppose, my lord, earlier this act is, my lord.
Or
Yes, my
read this part, or a certificate.
Yes, my lord. Suppose a person having, my lord, this FM pass certificate, or if there is no such candidate, my lord, having knowledge, my lord, because the rule is 1934, my lord, there are less qualified.
Very well, very well.
Yes, my lord. So, my lord, rule 4 clarified, my lord. If, my lord, anybody is found, my lord, he has, my lord, FM pass certificate, my lord, like petitioner, my lord, before your lordship, then, my lord, this, my lord, equivalent certificate will go. But here, my lord, he was given, my lord, preference over me. Just reverse of the rule, my lord.
No, where is it mentioned? Preferred.
My lord, rule 4, my lord.
Preferred.
Yes, my lord.
If they
Candidates for permanent post of Muslim registrar will be preferred if they have passed the Assam Senior Madrasa final examination.
Now you have passed.
I passed, my lord. This is my certificate, my lord.
All right, we'll carry on at 2.
Lordship,
Give the pledge.
since this matter is there in the part 2 actually, because of an order dated 21/8/2023, Lordship could see.
No, Lord,
The matter is now posted in part 2, your Lordship.
No, Lord, it is because part
Now-
1 it has come. Kindly, I may be allowed to. My
Now,
lord, it is, my lord, I filed, my lord.
Now, IA is pending, your Lordship.
Yes.
Made till then. Before going to the merits, in fact, I am better qualified. I am having the degree of MM, which is above FM. Anyways, your Lordship, but there is an order from this honorable court on 21/2/2023. 21st of February 2023, and the matter was directed to be listed in part 2, your Lordship. Accordingly, the matter is coming in part 4. This matter is coming up in part 2. Now suddenly this has come in part one along with this IA, your lordship.
My lord, this has not come suddenly, my lord. Lordship, kindly have a look. We both party, my lord, agreed and fixed this matter on several occasions, my lord. Dated, my
No,
lord.
there is a direction to list it in part two, so let it be
My lord,
listed in part two.
thereafter, my lord, in view of the, my lord, early hearing application, my lord. My lord, thereafter, in view of, my lord, IA,
Mr. Council, there is an order, should be listed. So even if it is listed in part two, you are entitled to make a mention, we'll upgrade and take it up.
my
There's
lord,
no problem there.
my lord, thereafter, my lord, several orders, we both party, my lord, fixed the matter.
But this
in the part
order
one.
perhaps was not pointed out. There is an order passed on 21-2 is correct.
My lord, thereafter, my lord, I filed, my lord, IA 607, my lord.
That's okay. You have filed. Where is your IA?
IA, my lord, 607, my lord.
Ah. What order was passed here?
No order, your lordship. It has
Then-
not been considered.
In view of that, my lord, in the from the part one, my lord, it was
It should have been listed for orders.
it was listed in the part one, my lord.
Matter be listed for orders along with the IA.
After, my lord, the part two order, my lord, I am not insisting. That's, my lord, I am pointing out, my lord.
We'll take up your IA.
So, my lord, now, my lord, any date may be fixed, my lord.
Yes, any date, give a date
My lord,
in October.
IA, my lord.
Fourth.
It will be
Obliged.
late, my lord, because, my lord, he is apparently, my lord, unqualified, my lord. And earlier occasion, my lord,
We'll take up the matter. Why are you insisting like this? We'll take up the matter. We are not, uh, the matter was directed to be listed. It would have been listed. If you had made a mention, we would have taken it up. You chose to file an IA.
yes, sir.
So this IA will have to be, some order will have.
I, my lord, paid, my lord. Then it was advised, my lord, file one IA, my lord. Then
Whatever, you have filed it, so
Yes.
we'll take it up. We'll take up the IA, we'll pass on.
IA may be listed in the next week any day, my lord. Kindly, my lord.
Not next week. Let it be on 27 then, 27
Obliged, lordship.
September for orders.
IA, my lord.
Mm.
IA, my lord, 6/07/2020.
Yes, yes, the IA is available here.
Obliged.
Good one. Seventeen. Who appears? You appear in 17?
Yes, my lord.
Yes.
For 17 and 18, both, my lord. In fact, 18, item number 18, your lordship heard the other side on the other side was not there. That's a short matter.
Item
18.
18.
There I am for the respondent, my lord. The petitioner side has already argued. I was not there, my lord. The matter was there. No, it's a short matter. Your lordship may pick up that matter first.
No, you are saying 17 and 18 are connected?
No, no.
Then?
Different. No, what I am saying is that item 18, your lordship has already heard the other bill. Since I was not there, my lord, as the counsel for the respondent, so the matter was adjourned on that.
Okay. Now we are on 17.
Yeah.
So,
Whichever your lordship likes to take.
no,
Because item
it is
17
for
will
you
take-
to,
Item number 17 will take some time. It's a disciplinary proceeding. But the other matter will be closed with a matter only one case, so I will rely on that specific lordship and finally dispose of. That was regarding.
where is the counsel for the petitioner in item 18? 18.
My lord, this senior is in another court. I may be allowed to call.
Yeah, call him. Call him.
Then I have to change my side.
So we are taking up 18.
Yes.
All right, item 17 passed over.
Item 18 is a my lord, disciplinary proceeding matter, so it will take some time. I'll do that, my lord, immediately after that. The petitioner's case is very simple, my lord. Their case is that they were appointed pursuant to a selection test and interview in 1995. And similarly situated persons have been regularized by an order of this court. That is their case. My learned friend can refresh your lordship's memory.
I'm sorry, my lord, I was in.
No problem.
My lord, in this case, my lord, first player is for claiming for regular.
Was this matter hard? Was it hard?
No, not my lord. On last occasion, partially, lordship has heard it
I don't-
on the division bench judgment, my lord. We said that our case is covered by the judgment of the division bench because the judgment of division bench has passed the notification.
Where is the division bench judgment?
That is, your lordship will find at page 47.
Yes. Please read.
Yes, ma'am. Paragraph 2, my lord. An employment notification dated 7/4/1995 was issued under signature of the Chief Personnel Manager of the respondent IOC AOD for 6 vacancies in the post of sweeper. In the notification, it was stated that the 6 vacancies are temporary in nature. As per the minutes of the selection committee held on 30/10/1995 and 31/10/1995 in the office of the Chief Personnel Manager, 9 persons were recommended for appointment against the unreserved category. I also one of the unreserved, whereas 2 candidates were recommended against SC category, 2 candidates against the ST category, and 4 candidates against the OBC category. The selection committee further provided that the selected candidate in order of merit may be offered appointment, the minimum of the pay scale, subject to being found medically fit and availability of vacancy. As per the recommendation of the selection committee, the 3 applicants herein were appointed and joined their respective posts on so and so respectively. The applicant made a claim that out of the candidates who were appointed pursuant to the recommendation of the selection committee in his meeting on 30/10/1995 and 31/10/1995, 11 of the candidates have been confirmed in their services, whereas the appellant who were also appointed under similar circumstances and as per the same selection procedure have not been confirmed. Consequently, appellants made a claim that they also be regularized confirmed in the same manner as has been done in case of the 11 other similarly situated candidates. In furtherance of their claim for being regularized, several representations were made from time to time, and in consideration thereof, various communications were made. In one of such communication dated 28/1991, this is important, madam, of the SPM, it is stated that although the temporary employees do not get all the benefits applicable to the permanent employees, but upon their request being examined, the authorities took the view that as the appellants are working against permanent vacancies, therefore the benefit of casual leave and medical facility be given to them. Another communication from the Chief HR Manager dated 28/3/2006 indicates that the question of regularization of the service of the temporary employees have been taken up with the competent authority in the headquarters and that the same has been pursued from time to time. The said two communication give an indication that the claim of the appellants for being regularized was under consideration of the respondent authorities in the respondent IOC AOT. But when nothing materialized, the appellant preferred writ petition so and so, which was disposed of by judgment or order dated so and so, along with another writ petition. In the course of hearing of the writ petition, the appellant relied upon judgment of Supreme Court rendered in so and so to contend that under Article 23 of the Constitution of India, even an employee was paid less than the minimum wages, it would amount to forced labor. Reliance has also been placed on the judgment of the Supreme Court rendered in the case of so and so,
And by referring to paragraph 55, it was contended that an employee engaged for the same work cannot be paid less than another employee. And it is the duty and responsibility of a welfare state to ensure payment of appropriate wages. Accordingly, the appellant raised the contention that they are entitled to be regularized in their service and be paid the same salary and allowances as payable to regular employees. On the other hand, it was contended on behalf of respondent IOC AOT that the employment notification of 7/4/1995 indicated that the recruitment would be in respect of 6 temporary vacancies. And therefore, the appellant, having been appointed pursuant to the state notification, they cannot claim the right of being regularized. In appreciation thereof, the learned single judge by the judgment and order dated 22/9/17 has arrived at a conclusion that the claim of the appellant are covered by the decision of the Supreme Court in people so and so, and held that the appellants are entitled to have their salary at minimum of the regular pay scale. Now, after that, para 10, being aggrieved by the non-consideration of claim for a direction to be regularized in service, the present appeal has been preferred. It is taken note of that in paragraph 13 of writ petition, averment has been made that 11 candidates appointed along with the appellant pursuant to the same selection process have been confirmed by the respondent authority. In reply thereof, the respondent IOC AOT had not denied such averment. And on the other hand, in paragraph 19, had admitted that in fact the 11 candidates who were appointed pursuant to the same selection process as that of the appellant have been confirmed in their service. The respondent authorities in their affidavit seeks to justify the same by taking a stand that the 11 candidates were regularized as they were above the appellant in order of merit in the select list pursuant to which they were appointed. The list of 11 candidates who were so regularized find place at page so and so of the memo appeal, which also contains the name of the applicants by showing that they are not confirmed as yet. From the employment notification dated 7/4/1995, it is discernible that there is no such indication that only some of candidates who are to be appointed pursuant to the process would be regularized in the due course as per their order of merit, and that the remaining selected and appointed candidates would not be so regularized. The employment notification uniformly provides that the appointments to be made would be against temporary vacancy. And although it refers to fixed number of vacancy, this is important, my lord, but it is admitted position that 9 unreserved candidates and 8 reserved category candidates were recommended and appointed. It is also an admitted position that out of the same, 11 have been confirmed in service. In view of such factual situation, the provision in the employment notification that the recruitment would be for 6 temporary vacancies had lost its relevance, and the same itself also cannot be a reason to regularize 11 of the appointed candidates while not regularizing the others. In the absence of any such provision in the employment notification or in the minutes of the selection, that some of the selected candidates would be regularized while others would be not. Next page, the procedure adopted by the respondent authorities to subsequently regularize some of such selected and appointed candidates while refusing the same treatment to the others would be arbitrary and discriminatory, and the differential treatment given on the basis of the merit position in the initial select list by itself cannot save such discriminatory conduct. In the absence of any such indication at the time of recruitment, no intelligible differential can be noticed between the selected candidate merely on the basis of their merit position in the select list, so as to entail a different treatment for the purpose of regularizing some of them while refusing others. Accordingly, it is concluded that the conduct of the respondent authorities in confirming regularizing 11 of the similarly situated candidates were selected and appointed along with the appellants, while refusing to regularize the service of the appellant in a similar manner violates Article 14 of the Constitution of India. The different treatment on the basis of the position in the select list do not form a reasonable classification for the purpose of regularizing or not regularizing in the service. Para 15. It is further taken note of that employment notification of 7/4/1995 clearly indicates that appointments were made against sanctioned vacancies, although they were indicated to be temporary vacancies. But the factual situation is such that all the appointees pursuant to the said notification, employment notification, continues to remain in employment till date. That is approximately more than 20 years. And it by itself is an indication that the sanctioned vacancies has lost its status to be claimed as temporary vacancy. Now, may I read further, my lord?
Insofar as you are concerned, what is your, where is the employment notification?
Yes, my lord, that is in their affidavit. There. I want to show that, my.
Yes, where is that?
If your lordship will come to their affidavit of corporation,
Yes,
it was filed on 2019 August.
R1.
Yes, my lord, R1, page 20. This is the common notification. Pursuant to this notification, application were invited for the post of sweeper. And if your lordship will kindly come to the page R2, page 23, that is the.
You applied for this?
Yes, through a selection process.
Okay.
Then after being successful, my lord, page 23, this is a minus of the selection committee meeting held on 30 and 31st August, so and so. And as per this minus of the selection committee, my lord, your lordship will see the following candidates were appointed in and placed in order of merit at page 24. Here your lordship will see the vital ring is there. I belong to unreserved category. So your lordship will see there are 9 unreserved categories. Out of that, my lord, serial number 1, 2, 3, 4, 5, they have regularized, my lord. Now what happened, my lord? Serial number 6, Netramon Soikia, my lord. Serial number 8, Sanjeev Kumar Sadonidar, and serial number 9, M. Madhav Rao. These are the appellants in the writ appeal, my lord. They, my lord, claim before the Honorable Division Bench for regularization. Now my position is your lordship will see.
You're only one petitioner.
Yes, I am the only person left out. That is serial number 7. And person below to me, my lord, they have regularized, my lord, in pursuance of the division bench judgment. Now there is another point, my lord. While they have regularized the service of serial number 8 and 9, my lord, they would ought to have regularized or consider my case also, being that division bench said that the subject matter of the selection was, my lord, cannot have any intelligible difference here. That 11 candidates will be selected for regularization and the others similarly situated would not be considered.
Yes.
So that is starting my basic starting for
Yes, what
regulation.
do you say, Mr. Chaudhary? We'll come back to you, Mr. Borwa. Just want to find out.
My lord, so far as factual aspects are concerned, my lord, there is no dispute. But I'd like to draw your lordship attention to certain breach, my lord, which may be relevant to appreciate, my lord, what I want to submit and urge before your lordship. First, my lord, this selection was held in 1995. And in 1997, other persons similarly situated, they were regularized, rightly or wrongly, living there. So cause of action for raising a grievance before this court arose in 1997. What happened to the minor other persons who were left out? They approached this honorable court by filing a writ petition in 2009. And writ petition was decided on 22nd of September 2017. Then, since it was not complied with, this writ appeal was filed. Writ appeal was decided in 2018. Now, the present writ petition has been filed in 2019. What I'm trying to impress your lordship is that actually they may be similarly situated with the persons who are left out and who is covered by the writ appellate judgment. But there is another aspect, whether a fence sitter is entitled to the relief. That is the only point I'll urge before your lordship.
Maybe, but in the face of a division bench judgment, which ultimately aim to be attain finality in view of the dismissal of your SLP, the fact remains that the ratio in the judgment is that similarly appointed persons
Yeah.
are to be treated similarly.
True.
If you don't appoint, if you do not consider other similarly situated persons, then it is hit by the principles of Article 14, and there is a reference of Article 23 also. Now, if it is your case that notwithstanding this finding, the petitioner does not stand on the same footing.
No, my lord, that is not my case. Let me be honest, my lord. That is not
So
my
if
case.
that be the case,
Yes.
then yes, he is selected in the post of a sweeper. So he may not have been have had access to proper legal advice for some reason or the other. He was not before the court, but at least he is entitled to be considered in terms of this division bench order
My lord,
judgment.
only one judgment I'll produce before your lordship, my lord, regarding the benefit that can be given to a fence sitter. Your lordship will consider it as a past order. Mother, I will not take your lordship's time unnecessarily.
Yes.
The judgment is, my lord, 2015 1 SCC, page 347. Yes,
347.
my lord.
What is the citation again?
Citation is 2015, volume 1 SCC, page 347. 347, yes. I'll read, my lord, one paragraph, my lord, paragraph 52, para 17. No, sorry. Paragraph 22.11.
Yes.
May I read 22, my lord? The legal principle which emerged from the reading of the aforesaid judgment cited both by the appellants as well as the respondents can be summed up as under 22.1. The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters more empathetically as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently. However, this principle is subject to the well-recognized exceptions in the form of laches and delays as well as acquiescence. Those persons who did not challenge the wrongful action in their cases and acquiesced into the same and woke up after wrong delay only because of the reason that their counterparts who had approached the court earlier in time succeeded in their efforts, then such employee cannot claim that the benefit of the judgment rendered in the case of similarly situated persons be extended to them. They would be treated as fence sitters, and laches and delays and or the acquiescence would be a valid ground to dismiss their claim. Your Lordship may also read the subsequent paragraph. However, this exception may not apply in those cases where the judgment pronounced by the court was judgment in rem with intention to give benefit to all similarly situated persons, whether they approach the court or not. With such pronouncement, the obligation is cast upon the authorities itself to extend the benefit thereof to all similarly situated persons. Such a situation can occur when the subject matter of the decision touches upon the policy matters like schemes of regularization and the like. On the other hand, if the judgment of the court was in personam, holding the benefit of the said judgment shall accrue to the parties before the court, and such an intention is stated expressly in the parties to the parties before the court. Such an intention is stated expressly, in the judgment, or it can be impliedly found out from the tenor and language of the judgment. Those who want to get the benefit of the said judgment extended to them shall have to satisfy that their petition does not suffer from either laches or delays or acquiescence. Viewed from this angle, in the present case, we find that the selection process took place in the year 1986. Appointment orders were issued in the year 1987, but were also cancelled by the order dated 22/6/1987. The respondent before us did not challenge the cancellation order till the year 1996 for a period of 9 years. It means that they had accepted the cancellation of the appointment. They woke up in the year 1996 only after finding that some other persons whose appointments orders were also cancelled got the relief. By that time, 9 years had passed. The earlier judgment had granted relief to the parties before the court. It would also be pertinent to highlight that these respondents have not joined service nor working like the employees who succeeded in the earlier case before the tribunal. As of today, 27 years have passed after the issuance of the cancellation order. Therefore, not only was there an unexplained delay and laches in filing the claim petition after a period of 9 years, it would be totally unjust to direct the appellant to give them appointment as of today after a period of 27 years, when the most of these respondents will be almost 50 years of age. So
Now-
I'm relying on this principle only, my lord.
No, the principle, there is no quarrel with the principle. How this principle is applicable, that you have to address the court.
Yes, my lord. That is why I said, my lord, the selection process was of 1995. In 97,
Is it a case of termination?
no, it is not a case of
It is
termination.
a case of claiming for regularization.
Yes, my lord.
Now, his claim for regularization, was it rejected at some point in time? By speaking order or anything like that?
In fact, my lord, there is no order as such that saying that your services will not be regularized. That is true.
So therefore,
But, my
his
lord, their
claim,
appointments were temporary.
so his claim for regularization remains.
My lord, in fact,
This is-
the basis of his claim is that other persons have been regularized, and other persons have been regularized.
Maybe he is entitled to make a claim on that. And you are required to give a reason as to why his claim should not be considered. Because the employment notice is the same, the interview selection process is the same, posts are the same, select list, the names appeared in the same select list. So everyone else has got the benefit except for this person. Now, yes, there is some amount of delay. But-
Long delay, my lord. Others were regularized in 1997.
97, no, how can they be regularized because this writ appeal is of 2018?
No, my lord, the case of the petitioners in that petition is that others have been regularized in 1997.
Uh,
That was their case. On
No,
that basis,
that's
they-
all right. When were the petitioners, when were the appellants regularized in the writ appeal?
This is repeated after the SLP order.
After the SLP order was passed when? 2018. So end of 18 or 19?
Well, I filed one reply. I have annexed the regulation order of one employee in my reply.
When was it there? When were they regularized?
Additional affidavit, madam.
No,
The
just tell us the date,
7/1/2019,
19. 7?
7 January, my lord.
2019,
19 or 20?
19, my lord.
All right, 19.
And I also filed in 19. My writ
Now,
Reply.
and person
so
below to me.
his claim for regularization really has not been rejected by the authority.
Yes. But my lord,
Will it mean that he has abandoned his claim?
no, what I'm on is that the stage at which he ought
Look,
to have come is
Your submission that there is delay in latches, that delay has to be counted from a particular date. So he has been asking for regularization. He's working, he's asking for regularization.
my lord.
His prayer for regularization has never been rejected.
My
To
lord,
say that yes, it was rejected on so and so date and thereafter 10, 15, 20 years you have come. That perhaps would be a case
no, he
in the
submitted, my
category
lord,
that you have projected.
he has been filing, my lord, representation. That is true.
But it has not been rejected.
My lord, in 2003, he has filed his representation, his document, my lord. In 2006, he has filed representation. But those are not answered, my lord. That is the time, at least, my lord, when he.
But they have not rejected it. If it is a case that yes, it was rejected, not communicated, available in the file, is one issue. But it is a case where you did not even consider his case.
That is one
So even today, his case is pending.
his representation of 2003.
Maybe, but they're pending.
And this, the judgment, whether this is a judgment in ruin, that is another.
This judgment on the face of it is not a judgment in rem because of the penultimate findings in para 19. But again, there is a question of whether it is a judgment in rem is to be decided on the touchstone of the ratios.
Right.
Because if every judgment is to be taken to be a judgment in personam in respect of the litigants, then what will happen to the concept of multiplicity of litigation
No, that will be
of
also,
cases?
that will also be beneficial to the lawyers.
That's a different issue.
Anyway, my defense I have placed.
No, you have placed, but we have placed another query for which we are waiting for an answer. Whether in the facts of this case, can you say that they are fence sitters? Because there is no you to count the delay. You have said they have come after so many years. In the case which you have referred, there was a case of termination. They were terminated. They didn't do anything. They waited for others to file cases, and then when everyone succeeded, they came before the court. Here is a case where he has not been regularized. His prayer for regularization has not been considered, not been rejected.
And the age also that the Supreme Court.
What is his age now?
Discussed, I don't know.
Around 55 to 56. So within 4 years, he's going to retire.
Hmm?
56.
What is the age of superannuation?
They normally have 60 years.
Then
55.
60. 60. Superannuation is
60. So at 55, you are praying for regularization.
No, my lord. I am saying, my lord, after the judgment of this division, my lord, I am coming to that point, my lord. There is exception to that. My senior panel, there is exception to that delay control, my lord.
Provided it is a judgment in rem.
Yes. There is an exception. I will address on it.
Yes.
My lord, first thing is that after the division bench order, my lord, in my read petition, my lord, that article 14, my lord, that cannot be again tested, my lord.
That again be?
That cannot be, my lord, tested again.
Ah.
Because it is already decided that they have been discriminated. And the language of the division bench order, my lord, that similarly situated persons should be given similar treatment. So I am also one of the person in the unreserved category at serial number 7, my lord.
Oh, that's
So
correct. But
my thing is
Mr. Chaudhary has pointed out that in this judgment, there are certain exceptions.
yes, I am coming to that.
Now, under which exception do you fall?
Yeah. Now, so far, my lord, my prayer for regularization that they cannot be disputed because there is one concept of the Supreme Court, my lord, that continuing wrong, my continuing wrong gives a continuing cause of action, my. And in that circumstances, my lord, your lordship will see my paragraph 19 of my read petition. May I read it there? Paragraph 19, page 14, my lord.
See, if you are relying on case laws,
Yeah.
then mere reference is not enough.
In my
You'll have to
read-
rely and you'll have to show that the
Yes,
principles are applicable to the facts of your case.
Yes, I'm coming, my lord. Where
Para 19.
Para 19 of page 14 of read petition.
Yes.
That the petitioner says that immediately on passing the aforesaid judgment by the Honorable Supreme Court, the respondent corporation ought to have given the same relief to all other similarly situated employees, including this petitioner, elected under the same selection process and serving under the corporation in grade 1 till today. But the respondent corporation still engaging the petitioner in grade 1. Grade 1 is the lowest grade, ma'am, on less than 45 days basis by giving 2-3 days artificial breaking. Having no alternative, the petitioner is now compelled to move this honorable court by the instant writ petition for a direction to the respondent authority to treat the petitioner as regular employee of the respondent authority and to regularize him as a permanent employee of the respondent authority with effect from the date of his initial appointment and to clear all the service benefits including salary so and so. Now your lordship will see the annexure of the corporation, my lord, page 46, annexure H. The letter issued by the corporation, my lord. It is in reference to the joint petition filed by all the including the petition. Here it is stated, my lord, that signatories of this joint petition dated 22-2006 and 13-3-2006. I am also one of the joint signatories. Here it is stated, my lord, the matter of regularization of service of the temporary employees have been taken up with competent authority at IOC headquarters, New Delhi, and has been pursued from time to time. Due to certain policy constraints, competent authority approval is yet to materialize. Meanwhile, your joint petition under reference has since been forwarded to IOC headquarters for consideration, and matter will also be pursued by AOD management for a favorable decision. After this, my lord, nothing has been done. Now, your lordship.
Yes.
Now, your lordship will see that after that, my lord, some of the appellants came before the court.
There is no quarrel on the facts, Mr. Counsel. Why are you repeating the facts? We have read it.
Yes.
Mr. Chaudhary has not disputed the facts.
Yes.
Mr. Chaudhary's only objection is that you have come after a long delay.
That I am
Therefore, that puts you, that makes you a fence sitter.
I'm reply to it that my lord by a
You share a copy with Mr. Chaudhary also, or at least give him a citation.
2008, it's my lord 2008 SEC, page 648. That is Union of India versus Tarsem Singh. That is on the concept
See,
of continuity.
I don't know if you are available, or you are able to recollect, but Mr. Chaudhary will certainly recollect. Mr. Borkotoki sitting there will also recollect that earlier, before hearing, you used to give the list of judgments by both parties, sharing across, so that both parties are aware what judgments you are relying on, and it's convenient for the court.
Yeah. And this is, my lord, very known.
So my suggestion or request is, before you proceed for hearing, you ensure that if there are any judgments, you share it and give a list to the court master. You don't have to give us photocopies. We'll take it out, but at least let us have the judgments.
My lord, I'm sorry.
Yes.
My lord, here may I read it there, my lord, had not passed, my lord. Continuing wrong.
No, not had not.
Yes, paragraph 4, my lord.
Yes.
For my regularization and my benefit, which I am entitled. Paragraph 4, my lord. The principle underlying continuing wrong and recurring successive wrongs have been applied to service law dispute A continuing wrong refers to a single wrong act which causes a continuing injury. Recurring successive wrongs are those which occur periodically. Each wrong giving rise to a distinct and separate cause of action. This court in so and so explained the concept of continuing wrong in the context of section 23 of the Limitation Act, corresponding to section 22 of Limitation. It is the very essence of a continuing wrong that it is an act which is a continuing source of injury and renders the doer of the act responsible and liable for the continuance of the said injury. If the wrongful act causes an injury which is complete, there is no continuing wrong, even though the damage resulted from the act may continue. If, however, a wrongful act is of such a character that the injury caused by it itself continues, then the act constitutes a continuing wrong. In this connection, it is necessary to draw a distinction with injury caused by so and so. Now, if your lordship will come, para 5. In M.R. Gupta versus Union of India, the appellant approached the High Court in 1989 with a grievance with regard to his initial pay fixation with effect from 1/8/1970. The claim was rejected as it was raised after 11 years. This court applied the principle of continuing wrong and recurring wrong and reversed the decision. This court held the appellant grievance that his pay fixation was not in accordance with the rule, but the assertion of a continuing wrong against him, which gave rise to a recurring cause of action each time he was paid a salary, which was not computed in accordance with the rule. So long as the appellant is in service, a fresh cause of action arises every month when he is paid his monthly salary on the basis of a wrong computation made contrary to rules. It is no doubt true that if the appellant claim is found correct on merit, he would be entitled to be paid according to the properly fixed pay scale in the future, and the question of limitation would arise for recovery. That is my question. Only for recovery that I am coming with. Area for the past period. In other words, appellant claim, if any, for recovery of areas calculated on the basis of difference in the pay, which has become time barred, would not be recoverable, but he would be entitled to proper fixation of his pay in accordance with rules and to cessation of a continuing wrong if on merit his claim is justified. Similarly, any other consequential relief claimed by him, such as promotion, etc., would also be subject to a defense of lessors, etc., to disentitle him to those relief. The pay fixation can be made only on the basis of the situation existing on 1/8/1970, without taking into account any other consequential relief, which may be barred by his blessings and the bar of limitation. It is to this limited extent of proper pay fixation, the application cannot be treated as time barred. Now, your lordship will kindly see, I will come to paragraph 7, that is important, 7 and 8. Of this judgment, reading judgment.
Karsem.
Yes. Paragraph 7. To summarize, normally, a belated service-related claim will be rejected on the ground of delay and laches, where remedy is sought by filing a writ petition, or limitation, where remedy is sought by an application to the administrative tribunal. One of the exceptions to the state rule is cases related to continuing wrong. That is my submission. Where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy with reference to the date on which the continuing wrong commenced. If such continuing wrong creates a continuing source of injury, but there is an exception to the exception. If the grievance is in respect of any order of administrative decision which related to or affected several other also, And if the reopening of the issue would affect the settled rights of third parties, then the claim will not be entertained. There is no third party matter. For example, if the issue relates to payment or refixation of pay or pension, relief may be granted in spite of delay, as this does not affect the right of third parties. But if the claim involves issues relating to seniority or promotion affecting others, delay would render the claim stale, and doctrine of lesser limitation will be applied. So in case of my lord, promotion and seniority, doctrine of lesser can come because it affects the third party. But here, my lord, is different. So may I read further, my lord? Another paragraph, my lord.
Is there any higher post? Is there any, these are not, there's nothing called a promotional post or anything like
No,
that.
no.
These posts,
Yes.
is there any scope for further promotion?
Yes, my lord. Later, after regulation, they provided to the other applicants. They
Okay.
provided. Now, in this case, my lord, may I read it, my lord? After this line, para 7, my lord. In so far as the consequential relief, this is important, my lord. In so far as the consequential relief of recovery of areas for a past period is concerned, the principle relating to recurring successive wrong will apply. As a consequence, the High Court will restrict the consequential relief relating to areas normally to a period of 3 years prior to the date of filing of the writ petition. So my stand is also that, my lord, if the corporation does not want to give full benefit of my own regularization, the consequential benefit, then as per the division bench sentencing judgment, my lord, 3 years prior to filing of the writ petition. That means I filed my writ petition in 2019, my lord. Then prior to 3 years will be in 2016, my lord. From 2016, my lord, I will be entitled to my area salary and other benefits. And another concept is that, my lord, in 1997, I joined in the service. And in 2006, your lordship has seen the IOC corporation letter in 2006 that they are considering my regularity. So for the period from 1997 to 2006, that period will also come. Only after 2006 to 2016, 10 years, there will be curtailment. For 2006 to 2016, there will be curtailment of certain benefits. But certainly, I will be entitled to certain consequential relief. Now, your lordship will see of the judgment para 8 of Tarzan Sim, plus para 8, may I read it, my lord? In this case, the delay of 16 years would have the consequential claim for areas. The High Court was not justified in directing payment of area relating to 16 years, and that too with interest. It ought to have been restricted the relief relating to areas to only 3 years before the date of writ petition, or from the date of demand to date of writ petition, whichever was lesser. In view of such, these appeals are allowed. So the
Right.
appeal was allowed, my lord, curtailing the benefit for the period of 3 years prior to filing writ petition. And in my case, my lord, I submit that, my lord, from 1997 to 2006, they were considering my regularity as per their own letter annexed at page 46. So for that period, I am entitled to, my lord. And from 2007 to 2015, my lord, there is some delay, my lord. Although I am been left out by them, there was some delay. So that I have to admit, my lord. So for that, I will not claim that.
All right, we'll see.
But from 2016.
Anything else?
Your Lordship permits, my Lord, only two sentences. One is, my Lord, the petitioner also filed representation jointly with the other persons. That was in 2003, 2006, and last reminder was in 2006. After that, the other co-representatives, other persons who joined in the representation, they have approached this court. He has not. So after, my Lord, the other persons filed the writ petition in 2009, he doesn't have any representation.
We have noted that.
That is one. And secondly, in the judgment, my learned friend was, my Lord, relying, what is a continued wrong that has been, my Lord, discussed in paragraph 4. Relying on an earlier decision of the Honorable Supreme Court, it is said that it is only an act which gives injury recurringly.
Act will include omission.
Act is an, my Lord, action.
Act will also include an omission.
In my humble submission, it will not, my Lord. If your Lordship kindly reads the, how, my Lord, the continued wrong has been defined.
No, act also includes an omission. Act, the conduct of the authority is not acting when it ought to have, can also be included within this ambit to say that it has caused an injury.
It's an action.
It's an action.
What it says, my Lord, the Supreme Court, what it says, paragraph 4, only, my Lord, your Lordship will kindly consider that the principle underlying continuing wrong and recurring successive wrongs have been applied in service law disputes. A continued wrong refers to a single wrongful act which causes a continuing injury. Recurring successive wrongs are those which occur periodically, each wrong giving rise to a distinct and separate cause of action. The court in Balakrishna so-and-so has explained the concept of continued wrong in the context of Section 23 of the Limitation Act, corresponding to Section 22 of the Limitation Act 1963. It is the very essence of continued wrong that it is an act which creates a continuing source of injury and renders the doer of the act responsible and liable for the continuance of the said injury. I don't have any further question. And the earlier writ petition, my Lord, out of which this writ appeal, my Lord, came, there was a prayer from Andaman. It's not, my Lord, quashing of any decision, not a circular right.
Yes, because there's no order to, there's nothing to quash. The direction is to pass an order.
Yes, nothing to quash means, my Lord, there is no action.
The act of, this is one way to interpret, which may also come. The act would mean
An omission.
one thing, that some order was passed. Act can also include a situation where you are required to pass, but you did not pass. Therefore, the act of not passing or sitting over a particular matter, will it also be included in the definition of?
I'll leave that to your Lord.
No, you don't leave it to me. We are inviting your interpretation. You can develop on this and tell us.
Because after the, my Lord, his representatives filed the writ petition in 2009, he has been acquitted. He didn't come. He didn't even file a representation. At least on the pleading, there is nothing that after 2006. So that means that, my Lord, he has accepted his temporary appointment.
All right. Reserved. All right. Yes.
May I
My
please
lord.
your lordship? Lordship, I have a prayer, lordship. Regarding the item number 17, lordship. Lordship, can it be possible for the day, lordship? I'm not prepared for the hearing, lordship, as the records are not available with us.
Why it should come up for part 2 hearing list? Should it not? The 21 matter.
This is a 2021 matter, but the matter he has been dismissed from service. So that way, my lord, it has brought. He was, my lord, placed under suspension in some time back, my lord.
So what we propose, what we thought we should go ahead is to give priority to the old matters as well as to new matters which have urgency. So if we have it in one list, it becomes easier for us to take up the matter. Supposing your matter today, this matter is listed now, some other date will have to be fixed in case it is not taken up. But if it is a part of a consolidated list, it can be taken up on any day. No further orders are required during the currency of that list. So therefore,
Agree to that. The person out of employment has.
no, I'm not on that.
Yes.
We want to take up hearing matters,
Yes.
preferably on Tuesdays and Thursdays, which is the reason why we thought consolidated lists would be better in handling hearing matters.
Right.
So it will be listed chronologically in the so far as the years are concerned, and older matters will definitely get priority. But some older matters will obviously may have become infructuous, or the petitioners may not like to press. That apart, there may be certain matters where, like this matter, if you are pressing for an urgency, we can take it up, notwithstanding it is a matter of 21. We can always take it up. But in the event the matter is not taken up, it doesn't go out of the list. It remains in the list to be taken up on any day thereafter.
And
But if it comes in a part 1 list, it's not taken up, it goes out of the list.
yes, your lordship is right. But at the same time, my lord, when it is in the, my lord, chronological list, it is listed down. And
That's what I'm saying. You'll have the liberty to make a mention for upgrading it.
for that, my lord, the consent of the other side is required.
Not necessary. Not necessary. If we want, we can take it up. Yes,
Lordship,
At least in this case, your lordship will pick the date.
she has agreed to that proposition. All right, we'll take it up. Give us a date. At the request of MS so-and-so, Bora,
Talukdar,
Talukdar, MS Government Council.
Lordship.
The matter stands adjourned. (26th September). Mr. M.K. Chaudhary appears for the petition, assisted by Mr. Sharma.
God bless.
God bless.
Yes.
My lord, this matter relates to a disciplinary proceeding matter. The petitioner was terminated from service in pursuance of a disciplinary proceeding, and that is under challenge. So I am basically challenging the order in 2 counts, my lord. Firstly, my lord, there was a procedural irregularity in while conducting the case. And if your lordship is convinced that this procedural irregularity part is on the procedural part, then lordship may not like to go into the other aspect of the matter. On the procedural count, my lord, there are 2 aspects. One is that appointment of the inquiry officer was prior to the framing of charge sheet. And secondly, my lord, the charge which was served upon the petitioner was not approved by the disciplinary authority, which is in clear violation of, my lord, the Assam Services Discipline and Appeal Rule. These are 2 on the technicalities, my lord. And thirdly, my lord, the own stand of the university, what university, the issue is regarding.
They follow discipline and appeal rules.
Yes, yes. And what happened, my lord? The petitioner was the director of GU Idol. He is a, my lord, part of the Guwahati University which conduct courses under distance mode. He was the director, but while he was working as director, there was a DAG report which was submitted before the State Assembly, inter alia saying that GU Idol has conducted certain courses, 21 courses, without getting the proper approval from the DEC, UGC. At that time, it was DEC, my lord. Subsequently, UGC has taken over. So that was the issue. And thereafter, my lord, an inquiry commission was Justice Aftab Hussain Saikia was appointed to conduct an inquiry. My lord, in the inquiry officer found that the report submitted was that all the directors, all the vice chancellors, all the registers who were working under that time during that period were jointly responsible for continuing this illegal these courses without approval, not illegal manner. And there was no financial irregularity was found because all the amount went to the bank account of the Guwahati University. And accordingly, it was submitted before the university, and in pursuance of that report, disciplinary proceeding was initiated only against the petitioner. I'm not saying that I should not have been brought under the purview because I'm not praying for any negative equality. Otherwise, my lord, though Justice Aftab Hussain Saikia report, my lord, said that every person were responsible, I was only singled out, my lord, and disciplinary proceeding was initiated against me. And my first two contentions are on the basis that the process which was adopted in violation of the Assam Services Discipline and Appeal Rules. Lordship will kindly turn to some. If Lordship thinks that the first 2 points are sufficient, Lordship may not even go into the other aspects of the matter, my lord, regarding the irregularities, procedural irregularities, and the perversity of the finding. Lordship will kindly come to page for a moment, my lord, page 50. Lordship has got it, my lord. This is the extract of the relevant section of the EC meeting proceeding held on 8/6/2021. I am the professor of foreign language under Guwahati University, and my disciplinary authority is the executive council under the Guwahati University rules, my lord. Lordship may kindly turn to page 51. Resolve that disciplinary proceeding be initiated. Resolve that disciplinary proceeding be initiated against Professor Kandarpada, Professor.
Who's for the respondent?
He was there, my lord. Mr. P.J. Puppan was there, my lord. I see. He was.
Yes.
And his name is also shown in the process. May I proceed? Resolve that disciplinary proceedings be initiated against Professor Kandarpada, Professor, Department of Foreign Language on Lian, former director of GU Idol, after legal consultation. Also resolve that is important. That is, Lordship, kindly note the date, my lord. It is on 8/6/2021.
You are reading from 51.
Page 51. Extract copy of the, my lord, EC visual meeting, my lord, which was held on 8/6/2021. That is prior to the framing of third seat, my lord. Resolve that Sri Pallab Bhattacharya, IPS retired, former chairman, Assam Public Service Commission, APSC, be requested to take up the responsibility to act as the inquiry officer to start the disciplinary proceeding. The registered Guwahati High Court will be the presenting officer for the purpose. Further resolve that Lordship may kindly turn to the next page, my lord, page 52. Lordship will mark the date, my lord. It is 10th of June 2021. Lordship has got it. It was issued by the register to Pallab Bhattacharya. Forwarding of Executive Council resolution dated 8/6/2021, which Lordship I have just read. Respected sir, with due regard, the undersigned as directed is pleased to apprise that your name has been suggested to conduct the departmental proceedings as follow-up action and forward your recommendations as per relevant rule of the university consequent upon the submission of Dr. Justice Aftab H. Saikia Commission report against Professor Kandarpada, who happened to be the director of Guwahati University Institute of Distance and Open Learning from 2006 to 31/1/2006, of which 6 years and 1 month
falls under the period of inquiry covered by the report of CAG. As such, you are requested to accept the offer. You will be paid so and so, my lord. Lordship, I kindly turn the last 3 lines from the bottom, my lord. As per relevant decisions of the Executive Council, matter is to be concluded within a month. My lord, they have not issued the starkey contest date, but they have requested the inquiry officer to conduct the disciplinary proceeding and to conclude it within a month.
That's only a suggestion.
My lord.
That is only a suggestion. That is only a request.
But otherwise, my lord, Lordship will see now case turn to page 54, my lord.
No, first show us the resolution of the university accepting the commission's report. There has to be a resolution that we have accepted. Findings of the commission report.
That has been accepted. I'm not disputing that.
Do you have a copy here?
That copy I have not annexed because the follow-up action of the is only a follow-up action of the report.
That is what I wanted to see. What was there in the resolution?
My lord.
What was the decision adopted by the university? Anyway,
Lordship,
then
turn to page 54 for a moment.
54.
54, Annex 7.
He has accepted.
Yes, it is dated, my lord, 17/6/2021. It is issued by Vallabh Bhattacharya to the register, my lord. On 17/6/2021, in inviting reference to above, I would like to convey my acceptance to the conduct of the departmental proceeding against Dr. Kandarpa Das, the then director of CU Idol, in pursuance of Justice Mahtab
My lord,
Commission report.
May I submit, my lord? Mr. Ken Chaudhary would lead me in this case. He has got some difficulty in the second part, my lord. So, my lord.
Lordship, I can make my submissions, my lord. He can note it down on the next day. He can reply. If your lordship otherwise not inconvenient.
No, it's not inconvenient, but it is inconvenient to hear it in piecemeal because we would like to hear the views of both the councils, and you give us a convenient date, we'll take it up. Because if it is not in succeeding days, then the sequence is broken.
Maybe it's on 12th of my lord September. 12th.
Yes, 21.
Yes. September.